guys, it's Kathy. I hope you're doing well. Mina, hi. I hope you're doing well too. So, um, I got some clips today from Discord. So people submit clips in Discord if they want me to show them, and I normally don't because you guys have all seen them on other channels. But today I took two from Discord. I think the first one was from Megan. I'll tell you who they're from because I'll have that ready when I play them. I don't place your videos here. That's where they're from. Yeah, so place your videos here is where I got them from. And it seems like people wanted to see Simpson. So Margaret gave me one. And then there's drone videos you got to check out. Spade. No. That's Judge Fleischer. That's Judge Fleischer. We're looking for Simpson. I just can't remember who it was. Oh, it was past securities stuff. Wow, I went so far back. Listen, once I play it, if you're the one that put it in there, call yourself out because there's so many in here and I can't remember exactly who the second one was from. It's way up in chat somewhere. Anyway. But first we're going to get through the rest of this trial and then I think I'm going to just skip trials for a bit. Maybe not. I lie a lot. Whatever I usually get whatever I get. Like I record and I get whatever I get. I can't pick and choose. But I can try. I can try to get more clips. And I don't know why I'm so red today. The light, I moved it as close as I could. I put my phone flashlight right on me, which was annoying. So I took it off because it didn't change anything. I turned on more lights. But nope, I'm red today. That's the way it goes sometimes. Bonjour. All right, I'm going to start with the trial. We have to get past it to the part we stopped at.
Asking for a legal.
What
There.
okay. And how did you come across seeing him do it?
The scent, and then going to the backyard.
Okay, what was in the backyard?
Him smoking with a group of friends.
Okay, so you observed this, is that right?
Correct.
And this would occur daily?
Yes, they.
Okay. And did he act differently after he smoked the marijuana?
No.
He didn't? There's no response to that.
Sustained after no.
Okay. Was there anything else besides cocaine and marijuana that you ever observed him ingest?
No.
Okay. Now he mentioned from the witness stand, he admitted that he took illegal pills that he wasn't even sure what they were. Did you hear that?
Yeah.
Did you ever observe him doing that when you were with him? I mean, during this time period?
Yes.
Okay. So there were other things you observed.
Correct.
Is that right?
Correct.
Tell the court what you observed on those occasions.
Well, on that occasion, I knew some were prescribed. However, after the treatment was completed, he would still go and refill those prescriptions. I'm not sure what kind of pills they were. I just know they were in multiple containers.
Okay. And after he took those, did you notice any sort of change in behavior?
Yeah.
Would you tell the court what that change was?
He would begin to hallucinate.
Okay, why? How do you know that he was hallucinating?
He would go in front of the TV and have a conversation with the TV. And he would talk.
Guys, we had a great time on Tokyo's channel last night? Not today. Still last night. It was last night. For me, it's today. Um, we had a great time. It was Tokyo and Bill for a while, and they were great. And then they sent me a link, and I hopped on too. And then it went south. But it was great up until that point. Now they know better. Now they know better. It was you should go back and watch it though. It was a blast. It really, really, really was.
We have Elf on the Shelf at the
I
time.
can't hear you, I'm sorry.
We had Elf on the Shelf at the time, and he would speak to the elves, and he would speak to the TVs, and he would speak to the drawings that he would draw on the wall.
You said he drew on the wall.
Correct.
What did he draw on the wall?
He would cover the entire room, full of graffiti, full of writings, full of quotes, just all over it, covered all up.
In your opinion, was he in a correct frame of mind when he did that?
No,
Okay. What do you think made him do that?
drugs.
Okay. When he was talking to the elf on the shelf and the TV, and the drawings, do you believe he was trying to be humorous?
No,
Was he serious?
correct.
Were there any other instances where you suspect he was hallucinating?
Yes.
Tell the court about that.
On Thanksgiving Day, he and the whole family was there. He went downstairs and confronted his grandmother, stating that she was helping me cheat on him and that the person was hiding in the
I
attic.
will
He
ban
then
you
went
all.
into the attic, and then he was looking for a particular person that was.
I was saying hi to Lisi, and you blocked me. Oh, my heart hurts. My heart. Lisi, I was trying to say hi back to you, and they blocked me. I think it was Maiko. If I had a guess, it was Maiko. And I'm gonna go look in my chat, and I'm gonna see.
Was not there. The whole family was there on Thanksgiving Day, and they tried to tell him that he's hallucinating, that it's a drug. And that was one of the main things that I do remember.
Okay. So on that occasion, at least, his whole family witnessed the effects of the drugs.
Correct.
Maiko, I was
Okay.
wrong. I'm so sorry.
So in addition to the drug use, did you ever observe him drink
Drink?
alcohol?
Yes.
And what did you observe him drinking?
Beer, liquor,
She's not in trouble.
How often?
You would be in trouble.
occasionally.
Okay, so this was not a daily thing.
No,
When he drank, did he get intoxicated? Objection.
overruled.
Did he drink to the point of intoxication in your opinion?
Yes.
Objection called for legal conclusion.
Just rephrase it. I mean, we're not asking for, I'm not asking for a legal
Right.
or a scientific, like,
I'll rephrase
blood
it.
alcohol level, but
Okay, did he drink until he acted drunk?
Yes.
And was that every time he drank, most times, or what?
Most times.
Okay. Did anyone else in his family ever see him drunk?
Yes.
Tell the court who all in his family saw him drunk.
His mother, his sister, his brother, the aunt, the grandmother, the cousins, nieces, and nephews.
So that's everybody, right?
Correct.
Did anybody confront him about this?
Yes,
And how do you know that?
I was present.
And without telling me what they said, what was his reaction to the confrontation?
Aggressive, upset.
When you say aggressive and upset, what particularly are you talking about?
He pushed his brother out the way and told him to mind his business.
And was there any other physical altercation on that, at that point?
On that day, no.
Okay. Were there any other things besides his use and perhaps abuse of substances that caused problems while you were together from January 23rd of 2012 until you and he separated.
Can you repeat the question, please?
Okay, I'm sorry, it was a long drawn out. During the particular time frame that we're talking about, which was from January 23rd, 2012, up until I think it was December 2019, is that right, when y'all separated?
Correct.
Okay. During that time period, were there other things that were going on caused by him or with his behavior that caused you concern or worry?
His lack of responsibility.
What do you mean by that?
He would never maintain a job.
Okay. What kind of work did he do?
He would work at the refineries for short time periods.
And what would happen to make the job end?
He would quit.
And how do you know he quit?
He would come home and tell me that he quit his
He
job.
told you?
Correct.
Okay. How did he, how was he treating you? In other words, how did he interact with you during this?
Horrible.
When you say horrible, tell the court specifically what you're talking about.
He used to punch me, kick me when I was down, slap me, pull my hair in front of my children and to my children.
Okay. So he punched you, you said?
Correct.
When he punched you, was it in the face, in the arm, in the, where did he punch you?
Objection
vague, if I can get a frame.
Overruled.
Where did he punch you?
He would punch me on my neck. He would punch me in the back of my head, on my body parts, on my torso, and that's about it.
Was it with a closed fist, an open hand, or what?
Closed fist.
Okay. And how often or frequently did this occur?
Frequent.
When you say frequent, tell the court how frequent it was.
5 times a week, multiple times a day.
Multiple times per day, did you say?
Correct.
And what would bring this on? Was there any particular thing that made you
You're not
punch you?
awake, Michael.
It was mainly whenever he was under the influence of what I believe was cocaine.
Michael, can you quickly grab Victoria a snacky snack?
You believe it was while he was under the influence?
Correct.
Okay. Now you mentioned punching. What else did you say he did?
He'll pull my hair
And how did he pull your hair?
from the back. He'll pull it back to the point where the bottom of my hair will be missing. Yeah.
Were you trying to get away? Were you standing there? What was happening?
Yeah, I would always try to get away.
And
You would always
what
try.
did he
I didn't
do?
hear what you said.
I would always try to get away.
Okay.
And what did he do when you tried to get away?
He'll grab me to pull me back in the room and to not get people involved, and then he'll close the door and he'll hit me
Did he hit you once or was it more than once?
more than once.
Okay, explain to the court exactly what he did to you when you got the door closed.
So when he closed the door, he already had me by my hair.
Thank you,
pulled me
Donald.
in,
Thank you,
closed the
thank you.
door, and then he's like, "I told you not to make a scene. Now everybody's gonna come tell me stuff," and then he'll push me down, and then he'll stomp on me. And
Stomp on you?
yeah, whenever I'm down, he'll
When
grab
you're
me.
laying on the ground?
Yeah, because he'll pull me by my hair and I'll fall down. So then he's like, "I told you not to tell them. Don't be making scenes. You're always making scenes."
Everything
And when I'm
works for
down,
Donald.
he'll grab his foot and then he'll just put it
Thank
on
you,
my back.
Fuzzy.
Did he put any weight on the foot?
Thank you, Tokyo.
Okay, did these things cause you pain?
Yes.
Is that a
Did you
yen?
ever call the police?
Yen?
Once.
When was that?
I want to say
That's
year?
pretty cool.
I'm sorry?
the year.
Well,
Three-
anytime, I don't know.
Uh,
Did you ever call the police based upon him beating you up?
Yes.
Okay, and you said, when was that?
This was
Thank
I
you,
believe in
Casey. Not nice, Fuzzy.
2016, 2016, 2016.
Okay, 2016. And what had happened to make you call the police?
He beat me to the point where I started bleeding from my lip. And,
Bleeding from where?
my lip.
Okay,
So then the cops got there. And when they arrived, I lied to the cops. And I told them that nothing was wrong. Everything was okay, that I was just upset at him for him coming home late.
why did you lie to the cops?
I was scared.
Were you the one that called the cops?
Yes.
Okay,
Also the neighbors from the apartment.
objection calls for speculation. I'm sorry,
Uh,
and here's a I called. She went on to testify about whatever people were doing.
well, I'm gonna overrule this time. I think you can address him cross.
Okay, so you believe that other people called the police that knew?
Correct.
Okay, and when the police arrived, what did you tell
That it was a misunderstanding. They did tell me that the neighbors also called because of the yelling and
them? Objection, hearsay.
Sustained.
Um,
No, wait, just wait for the next question now, okay?
Okay, and did the police just leave? Did they give you advice? What happened?
yes, we had,
Without telling me what the police said, I'm just asking
Yes.
you, did they give you advice?
yes,
And did you take that advice?
no,
Okay. How long did this pattern of him hitting you, knocking you down, or what else did he do? He hit you, he pulled your hair, he stomped on you. What else did he do?
he broke my arm.
Broke your arm?
Yeah,
Tell the court when that happened.
we were living in 220 Water Street. We were in an argument.
Objection, non-responsive. Which was when?
Sustained.
Okay.
I want to just break in for a second. I just want you to try to listen to the question because I do want to hear your story, but unless you're answering the questions that are asked, it's going to be really hard for me to get the story. Okay.
This is in Harris County, Texas, Michael. Do you think maybe, just maybe, we could say, hey, Victoria, can you go to the 247th District Court and fix their cameras real quick? And then she just walks in, moves their microphones around, fixes their cameras, and leaves. That would be so awesome. That would be epic.
So, yeah, my question is when? Like, do you remember what year or month?
I don't remember the year.
You don't remember the year? Okay. Do you remember how many years ago approximately?
I want to say it was, the children were probably like 10 years ago.
Okay. And how did you break your arm?
I was running away from him outside the home, running outside the 220 Water Street home. And then he pushed me and I fell, and that's how my arm broke.
Okay. And did you go to the doctor?
Yes, he took me, he had both of my children, and we went to Pasadena Bay Shore.
Did your children see any of this happen?
Yes.
Calls for speculation.
Sustained.
Were you in a position visible to the children when this happened? Objection, calls for
Correct.
speculation. If she knows you knew where the children were, correct?
Correct.
Okay. Were they at a window or outside, or where were they?
They were inside the home.
Okay. What was visible to them when the whole incident happened? Objection, speculation.
Sustained.
What was in the field, the line of vision when this happened? How far away were the children? Objection, speculation.
Well, it's compound.
Compound question. That was part of objection, speculation.
Sustained.
Okay. Was it in the presence of the children?
Yes, sir.
Okay. Where were the children? You said they were inside?
Correct.
Okay. Do you remember what room they were in?
It was in the living room.
And where were you when this assault happened?
In the living room, running outside the front door.
So you were in full view of the children. Without speculating, you were in full view, correct?
Sustained.
Correct.
Okay. They would have to be blind to not be able to see it. Is that correct?
Objection speculative. Actually, as soon as facts not in evidence, argumentative.
Sustained.
Okay. Is there any reason you can think of that they would not have seen it?
No.
Okay. How frequently or often did the children witness these assaults against you?
Objection calls for speculation as soon as facts not in evidence.
Overruled.
And
How often did the children see this? When they have to see these assaults, these batteries?
Before you answer, just wait a second.
objection calls for speculation.
Hi,
as to
Cass.
What they saw or didn't see and how often it occurred is purely speculation.
Well, she has testified that these things happened multiple times. I mean, you can ask her whether the children saw only this or more than this.
Did the children see only that incident that we referred to just now? Or were they in a position to see other incidents?
They've seen a lot of incidents.
And how do you know that they saw these incidents?
Objection potential calls for hearsay.
Potentially.
Okay. Without telling me what anybody said, how do you know that they saw it?
No,
Did they react?
just wait before you answer.
Okay, let me ask this question. I'll rephrase. Did the children ever react when these things happened?
Yes.
Tell the court how did they react? What did they do?
They would cry, they would scream, they would go call their grandmother.
Okay. And did anybody ever come to assist?
Yes.
Who came to assist?
His mother.
So his mother saw your children at least upset?
Objections calls for speculation.
Sustained as phrased, if you can just.
Okay. So your testimony is that his mother came over when the children would call, correct?
Correct.
And what were the children doing when she would arrive over there? Typically.
My son will be in between pulling at him. My daughter would cry and yell and scream,
So when you say pulling at him, who do you mean?
like pushing him away, like leave my mom alone, grabbing him, grabbing his shirt,
Request denied.
pulling him back.
And how did he react to that?
Sometimes he would just grab his hand and just hit him so he could move out the way.
Okay. So you said he hit child.
My son.
Okay. Was that the only time that he's ever hit your child, or what about your daughter?
I've never seen it with my daughter.
Okay. With your son, was that the only time you saw him hit him?
No.
Okay. Tell the court what else you observed.
On a specific situation.
Yes.
Whenever he would come under the influence of cocaine, he would automatically go to the room, attack me, saying that there's people hiding. Wake up the whole house.
Objection non-responsive.
Sustained.
Okay. I think you're trying to answer, but what the question is what other times specifically did he hit your son? Without giving me a lot of elaboration, just tell me what was going on or what was happening when you hit your son.
My son would try to get in between us, and that's whenever he would hit my son.
And how many times did that happen?
And I recall probably 5 times.
Okay. During this period of time, you mean?
To be fair, are we still in about 10 years ago?
No,
Okay, where are we right now? What's the time frame?
2017.
2017, thank you.
Okay. So this would have been between January 23rd of 2012 and December of 2019, correct?
Yes, sir.
Okay. Why did you stay? Why did you continue to stay?
I don't.
How old were you when you began living with them?
15.
Okay. Have you ever lived anywhere else besides with him?
No, sir.
What about your parents? Did you live with your parents very long?
With my mother.
Did anybody give you any advice to leave?
Yes.
And without telling you what they said, who were the people that told you?
His family, my family, my mother, his siblings, his sisters, cousins, his dad.
And what
Yes,
was your
Jojo.
what was your main feeling toward him? In other words, what was the overwhelming feeling you had?
Fear.
Fear? Okay. And why did you fear him?
Because of my experiences with him.
Okay. So did you ever, without telling me what was said, did you ever have discussions with your children about the family violence?
Yes.
Okay. And that was during the period of time that it was happening, correct?
Correct.
Okay. Since the day that you left him in 2019, have you denigrated him to the children? That means, have you said things that put him down to your children?
She knows what that means.
Have you told the children that he's a bad man?
No.
Now, earlier, Mr. Ortega's lawyer showed some sort of a posting on, what's it called? TikTok, is that right?
Correct.
Okay, did you put that up there?
No.
Do you know who it is?
Yes.
I'm sorry?
Yes.
And who do you believe did it?
My partner.
Okay. Did you tell her to do it?
No.
When did you find out that it was up there?
She told me.
And what happened when she told you that?
Immediately took it down.
So it's not up there anymore?
Correct.
Okay. So since the date that you and he separated, have you ever said that the children, to the children, that they should be afraid of their father?
No.
Have you ever told them that they should not go for visits with their father?
No.
Now, you saw a video that was shown earlier where your son told his father, when his father came to pick him up, that he didn't want to go with him. Is that correct?
Correct.
Did you tell him to do that?
No.
What did you tell him on that visitation day?
I told him to please go to give him another try.
Okay. And how old is your son?
14.
Would you be able to coerce him or physically put him into his father's vehicle?
No.
Is he taller than you?
Same height.
My son's 20 and I'll physically coerce him into a vehicle. Get in there.
Do you know, okay, without telling you what they said, did the children ever tell you why they were not going with their dad?
Yes.
Okay, let's get back to when you and Mr. Ortega separated.
I think I need to take a quick break. And Hutch, can you go get, I have another case that's offered.
Oh,
I had a case that was coming this afternoon that I thought they were done and had everything resolved. I have to talk to them briefly. It seemed like a good place to just pause. So if you could take a seat again with Mr. Delaney, and you all can take a break for 10 minutes, and please get Miss Elsie Martin Simon. Miss Martin Simon, can I, Miss Martin Simon, I want to do an approach with you and the I don't know how much.
They made her walk right behind him, and then he stared at her when she did. Look, watch.
Can I, Miss Martin Simon?
There he is. Boom.
I want to do an approach with
Jeez.
you and the I don't know how much more I can yell.
Okay.
Yeah, and I want the pro se lady.
Yeah.
And she needs to not bring her kid.
She's in the room.
Thank you.
Judge, I'm sorry, but this ear is stopped up with allergies.
That's okay. They're gonna get her. I just need the mom or the wife.
What?
Yeah, I need the wife.
I don't know if I cut this out, so I'm just going to bump it ahead a little bit.
Okay, and Miss Martin Simon.
No, I don't.
says.
We. Thank you very much. All right, Mr. Delaney, are you ready?
Yes.
All right.
Ms. Sanchez, once you and Mr. Ortega separated in 2019, is that right? Did he have regular visitation with the children at that point?
Yes, thank you.
And how often did he visit that children?
Every weekend,
You mean every other weekend?
every weekend.
Every week. And how long did that go
About 2 months.
on? I'm sorry, can you pull the microphone? Something.
Yeah, you can, there are two things you can do. You can scoot your chair closer to it. You can also move the mic closer to you off the record. You can move the mic like to the left. so
Thank
that it's
you.
more in front of the stand itself. You can move its hat itself.
Oh,
Yeah. That should help. Okay.
Okay, Judge, thank you.
Mhm.
How long did he do these usual visits?
I believe about 1 month.
About 1 month?
Correct.
Okay, then what happened after that?
Then after that, the children would come home crying.
And did you ever find out why? Without telling me what the kids said?
Yes.
Okay. So then what happened after that?
Can you rephrase?
Yeah, what happened after the kids started coming home crying? What happened?
I'll contact him.
And what happened then?
We would argue.
Okay, and you can tell me what you told him, okay, because he's here. What did you tell him when you contacted him?
I would tell him when the children would come home telling me,
And what was his response?
denying.
Okay. What was, without telling me, what was the essence of what the kids were reporting?
Objection, calls for hearsay, based off a hearsay statement.
Sustained, if you're, I think you're sort of getting to their state of mind, but you're asking specifically what, for the truth, so rephrase.
I'll ask it this way. Did what the kids say give you, cause to have fear or anything
Yes.
for their safety?
Correct.
Okay. And so you had a conversation about this with Mr. Ortega?
Yes.
right?
Any other witnesses or anything?
No, Judge.
All right, closing,
Yes,
go ahead.
thank you. Judge, we were here.
So I got some of mom and then I skipped a lot of mom so that we could get to the end without spending 17 days on this. I have the full hearing, the full case on my Patreon, which is here. And the second one will drop in about 2 hours. So the first one is there already from yesterday. The second one will drop in about 2 hours.
Here in May on enforcement, the associate judge heard that matter. At that time, I represented the court that I did not think that the mother would honor the court's findings of contempt and the makeup period's possession. And I said to this court, when I say this court, I mean willingly, that this is probably the first time I've ever asked that somebody actually be placed in jail for the willful disregard for a court order. I understand that people come before this court all the time on enforcement, and I stated to the court, I think this is the rare occasion where somebody needs to be placed in jail because I don't believe she will follow the court order. I don't believe that she takes the seriousness of this court's orders and or the relationship that
Now they want her in jail for this.
this father should have with a child. He has not seen his children in years. After this court held her in contempt, the next day actually that same day he attempted to pick up the children. It was actually right there. The next day he attempted to pick up the children, and you heard testimony from a police deputy or a deputy sheriff who testified about allowing the children to be a part of a conversation that he did not feel was appropriate. You've seen videos, her own video of him engaging with the father and the father saying, "Come with me." The next day, on the Friday after the enforcement hearing, he shows up. There's interactions. You've seen a TikTok video, which is clearly designed, I believe, to alienate the affections of a father and his children. You saw videos of the child crying, saying, "I miss you. I love you." Hearing the sister in the background crying and saying the same sentiment. That was in 2020. And you see the videos of their last exchange where what appears to be, and you heard him describe it as a happy visit, a happy exchange, or a happy time. That they just don't get it. I'm asking this court to do something that is very hard for me to ask for the court to potentially order, is to cut off access to a parent for a period of time. I absolutely believe it's necessary because in order for this gentleman who went beyond just saying, "I want my kids," he testified he went to a psychologist who is designed and set up to help come over and reach over the boundaries of alienation to reunify these two individuals with their father. He has reached out, he has gone beyond the saying, "Well, I'd like to do something." He took steps to try to address this. I don't think that if mom has any contact, that she will foster a relationship between him and these children. And that's horrible to say, but I think it's actually true that if we allow these children to remain in her care, she will not do anything to help bridge a gap that I believe that she created. Why? Because she said, "It was so important to me that he should have some contact that I went to the court and said, let's give him supervised contact."
Eating
But it's
contest.
important he has contact. And then she moved and didn't tell him where she moved to, so he couldn't even attempt to exercise his contact. They're talking about things that allegedly happened 14 years ago. They're not talking about what happened 3 years ago when he last saw his children. And I think the court can appreciate the fact that this father made attempts to see his children for the last 3 years unsuccessfully. But yet every Thursday during the school year, he showed up at 6 p.m. Every first, third, fifth Friday, year round, he had showed up attempting to pick up his children when he knew where they lived. On the summer periods of possession, he attempted to see his children and pick up his children. The Christmases, the Thanksgivings, their birthdays, Father's Day weekend, he has been cut out of their lives. And it's not because of the children. And it's not because of him. It is solely placed on the shoulders of the mother who intentionally, willfully disregarded a court order and cut him out of these children's lives. I can't imagine what this individual has done to keep it together to say, let me have a relationship with my children. Let me work through the court process to have my day in court so that I can see my children. I can't imagine that these two children who sat there and said, smiles in 2021, missed you in 2020, gone years without seeing their father, and now they're sitting there saying, I hate you, you're the abuser, you did this, you're a horrible human being. These children were abandoned, and they think it's because he abandoned them. They have heard things because of mom. She has been in their house, or they've been in her house. They are with her partner who creates a TikTok page saying the abuser. And they are friends with this person on TikTok. There's no way to say that she has attempted to foster a relationship. She has done every bit of alienation. So we're asking that he be named a custodial parent. We're asking for him to have exclusive rights and duties. We're asking for him to.
So him abusing is okay, but him being called an abuser is alienation. Got it.
Have possession and access, and that mom have no contact for 90 days. We're asking that he engage the children into therapy sessions with Dr. Shea. We're asking that she pay child support based off of $54,000 for 2 children before the court, if the court cares to do that. We're asking that the children be brought to this court and placed into his care because they will not go into his care at that house. Mom will not do it. The partner will not do it. It just won't happen. And we are just building and creating a bigger problem for the future. I was describing this to my client the other day. And as I described it, I said, imagine a cup. And I pour Drano in that cup. And I say, Armando, I want you to drink this cup. His response
Drink
is,
it,
no,
baby.
why not? It's
Drink
poison.
it.
Pour out half the cup. Said, now it's only half. Drink the cup. No, why not? It's poison. I keep on pouring it out until there's 5 drops in this cup. I said, drink this. His response is no. Why not? It is still poison. It doesn't matter how much of poison is, it's poison. Ms. Sanchez is poison. She has done everything within her powers to keep this man out of their lives over the last few years. She has done nothing since this enforcement hearing to re-engage these relationships. She has poisoned the contact she has with them. The sips they take from her will be poisonous and will affect them long term. I'm asking that the children be brought before this court and turned over to Mr. Okay. Thank you, Judge.
I don't think either of them asked for this, but this is just what I think they need. I think they need a counselor to work with dad and the children, and the counselor decides based on what everybody is saying, what happens, what steps to take to go forward. I mean, I I honestly don't think she belongs in jail, and you can't rip them away from her and give them to dad for 90 days when they clearly don't want to see dad. My children had choices to see their father or not see their father. You know, when he left, he didn't speak to them at all. And then he would text like once every 8, 10 months and say something. And they would text him, no reply. They would invite him places, never show up. They were finally like, you know what? Fine. Bye. That's it. So then when he started texting them again, he's like, hey, I miss you. You want to come over? No, I don't want to come over to your house. What? You don't want to come over? Why? What happened? What do you mean you don't want to come over? That, I mean, that had zero to do with me. I wasn't even in the text messages. But they need, but if there was like a therapist to work with dad and work with the kids to say, you know, this is what the kids need. They need you to acknowledge what they feel happened in the past, and you know the kids need to um, go through therapy to get past that and see if reunification is even possible. So I mean, if that man saw somebody beat up his new wife, let's say he has a new wife, and he saw someone beat her up, um, then he was forced to go live with that person. I mean, I know that's someone that's not a father, that's not a parent, but it's the same thing. They did witness what they witnessed, or at least they believe they did. They believe they did. So I know he's the dad, but he did some things in the past that it aren't okay. So now he has to fix it and not just say, "Oh no, I'm the father. They come with me." No, you got to fix what you did.
Thank you, Mr. Delaney.
Yes, Your Honor. It's interesting that my opposing counsel uses the analysis of, or the analogy of poison, because I can't think of anything that's more poisonous than a man that regularly beats up his wife, regularly does it in front of the children, regularly stomps on her stomach. We've heard testimony that this guy over here stomped on her stomach, and that came from his sister. This was not somebody that would tend to give some sort of a biased testimony out of being in favor of my client normally. This is somebody
Hey,
who had
Jesse.
to defy her parents, frankly, and a lot of family pressure to be here today. And she said the reason she did it was the children. She said that she knew that the children would not be better off with this man than they are with their mother. And even objectively, I think if we look at the situation, these children really don't even know their father, okay? Regardless of the reason, I mean, they do not know their father. To put them in all of a sudden the custody of a man that they really don't know, and in fact believe that is hostile to them and to the only person they know that has loved them their whole lives, would be cruel. It would be frankly cruel. Mr. Ortega is looking out for Mr. Ortega. He's not looking out for the interests of the children. He may or may not actually miss them and want to see them. Quite frankly, if you look at the whole course of his,
He has a criminal record. He has been to jail for other things in and out of this. So, but not for abusing her. She never pressed charges until she left.
relationship with my client, his fatherhood of the kids, it doesn't speak well for him.
He absolutely has a right to see them. He didn't lose his right to see his children because of his past actions, but he has to fix it. I mean, it's not just he can't just pretend nothing has ever happened and then they owe him. They owe him so much because he's the father. He owes them. He's the father. He owes them, you know, to meet their needs. That's his job, to meet their needs, not them to meet his needs. The kids don't meet parents' needs. They never ever meet parents' needs. Parents meet kids' needs. So they need to go through counseling. They need to go to therapy.
And abused drugs to the point that he was having hallucinations while he was in the home. He, according to my witnesses, hit the children. He, frankly, doesn't deserve to have custody of the children based on his past conduct. Now, Mr. Ramirez is trying to convince the court that this leopard has changed his spots. Well, there's an old saying about leopards changing their spots, and there's a reason for that. It doesn't normally happen. Of course, this guy is trying to hide his true propensities, and he's trying to hide his background as much as possible. The only background that you've heard today about his violence certainly didn't come from him. And yet it's substantiated by more than one witness. Unfortunately, my client's mother couldn't overcome the language barrier that she was prepared to offer
I'm not
testimony.
objecting as to what she would testify.
It's an offer. I'll consider it as an offer of proof. Go ahead.
Your Honor, we are asking that the court interview the children prior to making any decision. The court heard on one of the videos that was played, that was actually the father's exhibit, the children or the child say in a big argument that Mr. Ortega tried to get into with the child about not going with him. It was frankly a very awkward and pressured situation. But you heard the child say, I don't want to go with you. You act like I didn't see you hitting my mother, and that I don't remember what you did. He does remember. And he said that he does not want to go with his father because of those things that he was exposed to. And his father tried to play the card of, well, why are you saying that now when in 2021 you didn't say that? Well, he answered. He said, because I know now that a father's not supposed to be like that. The only thing he knew was abuse. That little boy grew up knowing abuse at home and knowing family violence at home. When he finally got a break from the abuser and started to realize that that's not normal, then of course he doesn't want to go back to that horrible, horrid existence. And Your Honor, I mean, the poison is sitting right there. The poison is a man who is violent, has a temper, gives disregard for his kids for years. And
Soon the judge talks, and it's a bit shocking to me. It was a bit shocking to me.
if the court were to return the children right now to him, I don't know what would happen with the children. I mean, they're old enough. They're 13 and 14. Your Honor, I think that we'd be leading to a situation of runaways. I don't think they would stay with an abuser. I think that they would, as soon as they got a chance, leave, and then we'd have a whole other problem. But especially in a case like this, we're at temporary orders, Your Honor. He didn't show anything on the witness stand as to how the present environment of the kids is threatening their physical health or emotional well-being. I think that quite
The
the
school
contrary,
grades
doing that with him
were
would
bad.
threaten both their physical health and their emotional well-being. The court needs, I think, more development of this case before flipping custody. I think that we need to do some discovery. I think that we need to have maybe some experts brought in. I think that there's a lot that needs to be done before we all of a sudden, on the spur of the moment, flip custody, when there's been this sort of evidence introduced as to actual physical abuse. There's a lot of risk that would be involved in returning these kids to the father. I ask that the court interview the children and at least hear what has happened in their own words before the court makes some sort of decision flipping custody and giving the
Or
abuser
a
custody of the
therapist.
children. Thank you.
Thank you. You all, your client, Mr. Delaney, doesn't have a counter petition on file, right?
No.
Okay. What is the game plan to follow the order?
As far as the visitation goes,
Mhm. Yeah, what's the
Um,
game plan? I mean, look, I saw a child, at least one in particular, who seemed to think he was pretty entitled to call the cops and call his dad names. And I mean, what's the game plan? That's just going to continue for forever? Seems, I mean, not forever, thankfully children grow up, but that's not sustainable. I don't see how it's sustainable. Are there any alternatives that mom would propose
Therapy.
that would fix some of that? Or is her position that in fact they should have no possession, that he shouldn't have contact with them?
Your Honor, I believe, and I don't want to speak to my client, but I believe that her position is that possession by the father probably needs to be supervised for a while. And I think her position would be that the children already go to counsel. I think that probably involving a counselor in a reunification plan might be a wise
Finally.
decision. But I don't think that we can just disregard what appears to be the real reasons. If you read the expert literature about parental alienation, alienation is only a diagnosis if there are no legitimate real reasons for the child's antipathy towards a particular parent. The child's antipathy is not equivalent to having been alienated. And so I don't want the court to automatically jump to alienation as a diagnosis. I think it needs to be investigated further to determine if it's even there. It could be that these kids are having a natural, authentic reaction to what happened when they were at home. But regardless,
Unfortunately for him, he went from the game plan for the children to see their father into alienation again, which is the point of the hearing, but not the point of the judge's question. If he would have just kept going down that road, we need, a plan. We need a therapist. We need a unification. But he lost track and went the left.
if in fact the father has turned over a new leaf, which is what he's claiming, then he needs to prove it before all of a sudden we give him custody.
But yeah, I mean, I understand that argument. But right now, he's entitled to pick up the kids tonight.
Right.
I mean, it's,
And Your Honor, I mean, with whatever influence I have, I will implore my client to follow the order that was rendered by the court and entered by the court. And I will myself try to improve the possession situation.
Judge Bear respond to that.
yeah, you
It
can,
won't happen.
I mean,
We were here a few weeks ago, and you made it a very clear point to Mr. Delaney and I that the child's birthday was on that Monday, and that visit would only be about 2 hours, and it was only for one child. And Mr. Delaney said the same thing. I will talk to my client. I will implore my client. It didn't happen. The child came out and said, "No, tired. You ruined my day. Get out of here." And I don't know. I understand where the court's at, and I talked to my client. This is a horrible situation. It is truly a damned if you do, damned if you don't. If you do it, you got a 13, 14-year-old who Mr. Delaney said may do certain things. Well, guess what? They're going to do it because mom's empowered them to think you don't have to go with this guy.
mean, I don't, yeah,
And
they
I mean, the
definitely
only thing
feel
we can say is
empowered.
he's reached out to, and
And that's the part that shocks me. I wanted her to talk about the mom and the dad, and instead she went with the kids are empowered to choose what they want.
I respectfully disagree with that statement about the empowerment. He was seeing the kids. It stopped. She did not open the door. They didn't see each other. I
Okay.
mean, there was no, I mean, that's
The two videos
correct.
that I saw with that young man, he doesn't think he has to listen to anybody.
Well, and that was after the enforcement hearing.
I know.
But up until that enforcement hearing, they didn't even open the door. Mom has the ability to go there and to say, kids go, Dad, no, we don't want to go. Okay, you're grounded. She didn't do that for years. Until the enforcement, and then she opens the door, and the kids literally looked at him and turned their back. And she just sat there. And his response is, I can't physically grab him. I can't make him get in the car. I don't want to do that. And I can understand that because the second he touches those kids, they're already on the phone with the cops. I mean, how many 13, 14-year-olds do you know that call the cops standing in front of the two parents and the mom saying, hey, it's under control. We got it. You don't need to call the cops. I'm the adult. I'll take care of this. No, the empowerment was she stood there and watched them call the cops. The empowerment was a sheriff's deputy showed up with them at the very first exchange possible after the enforcement hearing. And the officer said a few times, I believe it was 3 times, hey, why don't you let the kids step aside? And so the adults can have a conversation. Didn't say, I'm going to force you to make these kids go. Just said, let's have a conversation without the children. And the partner said, no, they're staying here with mom 6 feet away from them. That is empowering those children to say, we're not going to follow this court order. That is just as bad as her saying, no, you're not going to go.
Yeah, I think I agree with you. I think that we're on the same page as far as the empowerment.
But Your Honor, is the answer to that to punish them by putting them with somebody they absolutely don't want to be with? And
Do I know if that's the best thing for the children?
Yeah.
I'm not sure.
is that the proper punishment? Or maybe this guy feeling more entitled than he should at 14 years old?
I mean, nothing that I want to do would involve punishing the children.
I think that when we're talking about correcting somebody who feels too entitled, that's a punishment.
Well, but that's not something that dad is able to discipline. Mom doesn't appear to
Yeah.
be working on
Your
that.
Honor, we don't know if dad can discipline or do anything.
Sure, because he hasn't seen
We
his
don't
kids in
know. I
3
mean,
years.
all we know is that he's
Sorry.
thinking.
I don't want to be arguing
Okay.
about it. I probably started that.
So I will say and I'm not going to say happy medium, but a solution potentially is, you heard her testify that she makes $54,000. You heard that he's talked to Dr. Shea. And I don't know if the court's familiar with her as a psychologist.
How do you spell Shay?
Camille Shea.
How do you spell the Shay? S-H-A-Y, S-H-A-E? E-A.
Shea.
Thank you.
And so I think she used to be with Joan Schneider Anderson's group, and then went out on her own years ago. And I've been I've been an amicus in a case involving her years ago. And that's how my only connection to her is through a role as an amicus. I know Dr. Schneider Anderson no longer does private counseling. Dr. Guess does things, but she does not do evaluations. She does therapy sessions.
Well, are you asking for an evaluation?
No, not at all.
Okay.
These people can't afford it. So for him to say, let's engage an expert,
Well,
I mean, they can't afford it. But
so,
we can at least say, mom's going to take these people, or these children, to a therapist and put them in front of that therapist for a few times. Let dad meet with this therapist a few times, and let that therapist figure out how to bridge the gap. He loses. Because guess what? We have a court order on enforcement with makeup period of possession that he will never get.
okay, I didn't hear anything from Dr. Shea. If she had been a witness, would she say, I've spoken enough to the father to know that I'm willing to try it?
So the one thing I can say is that he reached out to her at my suggestion, and said, make contact with her, talk to her about kind of generally what's going on from your perspective, and have somebody ready to go to begin some therapy with these kids, because they're going to need, period.
Yeah.
Okay. So we can't just sit here and say, I get their position, let's grab them, put them over here. Well, they're going to fight back. They're already fighting back. And he can't just sit there and say, well, you know what? I don't care, because you know what? I have 3 years of tries saying he cares. But there has to be something, and doing nothing is not going to work. And saying, well, I'm going to talk to my client and make this, really stress to her. She needs to follow this order. That's not going to work. It's just not going to happen.
Right.
I don't envy this court's potential dilemma.
Yeah.
But
And Your Honor, I think earlier, before we even started the hearing, you did indicate you would interview the kids before making a decision.
I think I have to. I don't
Okay.
think I don't think that's
I'm not
disputed.
disputing it. Okay.
What I'm going to do most likely, and I want to end momentarily, is have the parties or the attorneys speak to Rosie to schedule the interviews. I will go from there.
So
Okay,
I can say, I don't anticipate sitting in the court, in chambers of the court while they interview. I'm not gonna ask for a record of that interview. Unless Mr. Delaney's gonna do that, that's.
no, I don't want to have a record. I don't want anybody in there but the judge and the kids.
And he doesn't have possession, so it's not even, let's talk to me about scheduling him to bring the kids up here.
Correct.
It might be,
On the other hand,
when we meet with the kids, and when are you going to come back for a rendition and or.
Right.
That, I understand that, and just
Okay.
to let the court know, I just received a text saying that Carmen was leaving Montgomery County. And so somebody needs to be thinking of.
I have to leave also. You all are excused and the court will be, please reach out to
Yes,
Rosie to get this then scheduled.
That's right.
And then further instruction, if there needs to be further instruction about appearances, the court will make those. Okay,
Thank you, Judge.
thank you. Good luck.
Can we meet you?
You may.
Whew, okay.
All right.
That was good. So they're not going to take possession from the mother and pop him into the dad right now. They're going to first talk to the kids, then talk to Dr. Shea, which is exactly what they need to do. First talk to the kids and then talk to Dr. Shea. And I hope that the son is a little better. I mean, I get his passion and his feelings, but I hope when they talk to the judge, these custody cases are never like you go to court once and then it's over. So she's going to try the therapist. They're going to talk and then they're going to come back and they're going to make a plan where he gets him this many days and that many days with the therapist. And then he'll get him for supervised and then he'll get him for overnights and things like that. And then they'll go back to court again for another hearing for more hours. Then they'll go back to court again for another hearing for more hours. And then the kids will be 18. And then that father might be in a little bit of trouble. So he needs to work on this right now. He deserves visitation. I think it just has to be done right. I mean, they have to fix the kids first. They have to go through a therapist. They have to learn how to do it. So she didn't rip the kids away from mom, and she's gonna talk to them. Which who knows? Who knows what she will feel after she speaks to the kids. Um, Maybe, but that ship sailed. That was years ago. She's been no contact with him for 3 years. That's in the past. For her anyway, and for him apparently. So he just has to get it in the past for the kids. They has to work on that. But they're with their mom still and her partner. Oh, okay. Now we go to 2 clips of Cedric Simpson. And I don't know why, but the audio is not great. I thought the audio in Judge Simpson's courtroom was on point, but it's not on point. But no, I guess that's like most courthouses. This lawyer is fan freaking tastic. I don't you guys probably already saw this, but the lawyer the lawyer had me cracking up. Here we go.
That email. You sent that email.
I sent that message. I don't respond to.
Okay.
He's new, Donald.
Court does call the case of the people versus Cedric Green.
Good afternoon, Your Honor. Christina Constantino, appearing with and on behalf of Mr. Green. Mr. Green, can you state your name for the record?
Thank you, sir. All right. Where are we this date?
This
Time
is
set
the
for
other one.
preliminary
This is the
examination.
funny lawyer.
Yes,
Sorry,
Your Honor.
that's next.
At this time, the defense would be moving for dismissal of this matter.
Hello,
This
Mr.
is the date and
Adams.
time set for exam. It's my understanding that the complainant is not physically present today and is not, I guess, prepared to testify. It's my understanding the complainant is lodged currently at the Washington County Jail. It's further my understanding that the complainant, should she testify, would be recanting her previous statements to police, which give rise to the case at hand. Given that, Your Honor, we would ask for the court to dismiss this case due to several reasons: the recanted testimony, failure to appear, as well as judicial economy.
And I don't need an immediate response. I will indicate that we had an in-chambers conference about this. And Ms. Constantino, I think, puts it all correctly, but the other reality is that the people are able to proceed and start the case. Despite, well, I'll put it this way. It may end up in a situation, and I think it's important for you to understand this, Mr. Green. It may end up in a situation where, while the people may not have to call that witness, your attorney might have to on your behalf. I don't know that that decision has been made. Okay. Complicating that, if you don't understand what I'm trying to tell you, I'll try to explain it a little bit better. Complicating that is that the complaining witness is represented by counsel. I don't know, and I'll put it sort of as vaguely as I can, whether or not that individual would be required or would be asserting her Fifth Amendment rights against testifying. Having said all of that, and the fact that the people can proceed, I do also understand that the people would be asking for an adjournment in the event, but are in a position to start the exam. And I would permit them to go forth and start the exam, but it would be adjourned to my next date, which would then be October 8th for the continuation of the preliminary examination. But there are all these other issues that rise up in there in the case. So for those reasons and the fact that the people can indeed begin the preliminary examination, I would deny your request to dismiss the matter.
Thank you, Your Honor.
Did you go ahead? Did you two want to talk? Because
Yes.
it looks like.
Judge, could we have a moment to talk? And I would also ask if the people could clarify how they wish to proceed going forward without the complainant's testimony.
Certainly.
The people. Absolutely.
No, absolutely. So a couple of things. First, I have made an offer in this file. The offer is that the defendant could plead guilty to an added count of domestic violence, the second offense, as well as a misdemeanor of attempt to resist obstructing the police. I have not received acceptance of that offer. Instead, I understand the defendant is interested in moving forward with the preliminary exam. Nonetheless, that offer has been made. Should we start the preliminary exam, I will understand that offer to be revoked. Second, in terms of moving forward, the people intend to proceed pursuant to MCL 768.27C, which is a Michigan statute that permits the prosecutor to move forward at a number of hearings, including the preliminary exam, without the victim's testimony. I'm not required to call her to testify. I've actually elected not to call her to testify today because I am not required to. I do have the officer present and I'm ready to move forward with this testimony. That statute permits the officer to testify at preliminary exam to all of the statements that the victim said to him. I do intend to move forward with the home invasion in the first degree, domestic violence in the third, domestic violence in the third degree, resisting, obstructing the police, and then of course counts 5 and 6 are tag along. I would not be moving forward with the building. And finally, in terms of judicial autonomy, while I do have the police present today and I am ready to start this exam today, I do believe that it would be in the defendant's best interest for the entire exam to be adjourned for his defense counsel to attempt to meet with the victim prior to having the officer testify about her statement. It might be beneficial to the defense to know what the victim has to say prior to that. Regardless, the people have to request an adjournment, at least for identification of the defendant and for count for the resisting obstruction. But as I said, I'm ready to start today.
And it was my understanding, from what the court indicated, that the court would be inclined to grant an adjournment should the people request that. Is
Yes.
that a fair statement?
Absolutely. If they are positioned to start today, I would allow them to start. I would then adjourn for the other charges to my next day. Okay.
And just to clarify, Your Honor, that means that you would allow the people to start the exam today.
Yes.
They would have 2 witnesses testify today. So witnesses testify today. And then you would allow an adjournment for the people to bring their 3rd witness, another officer, to appear on October 8th.
Correct.
Is my understanding that's the court's ruling.
Yes, that is correct.
And to be fair, I may only have one of the 2 witnesses testify today. I may not.
One of the 2. Okay. But you could start.
Yes.
That's the bottom line.
Okay. Judge, if I could have a moment to speak with my client, I would appreciate that.
Okay.
Could I?
Yeah, yes, Mr. Green, they're gonna take you back and then she's gonna come around and talk to you. Okay? Oh. Thank you, sir. Quarter past that case. All right.
Maybe I got the wrong video. It's this attorney right here that is funny. This attorney, I must have rewound it too far, but that's okay. We love Judge Simpson.
To play the video, the court is not on the table.
You're gonna need a,
It's in our home now. Oh, thank you.
Plus, we get to see a lot of Mr. Allen.
is it in the podium?
Yeah, she was.
Don't let her start pulling wires out of there. No, not, see, that's what I'm talking about. Next thing we'll be wired, we'll have this place wired like a Canadian home and nothing will work. I know, it's a teaser.
Thank you. Thank you.
Wow.
All right.
All right, ready? Court does call the case of the people versus David Epps.
Sleep is good.
2 cases.
Here she comes, guys. I wish we could hear her better, but
Good
we hear
afternoon.
enough.
Go ahead. They've stated their appearance. You can state your appearance, counsel. All right. Your name, sir? Thank you. All right. Are we ready to proceed?
Yes, Your Honor.
Come up to the podium. You'd like to make a motion to dismiss?
Yes, or not proceed.
Okay, or not proceed.
Dismiss.
Okay, go ahead.
Dismiss. As a matter of law.
All right, go ahead.
I told the people I was gonna make the motion. She asked me based on what I told her I would let you hear it, and then she can hear as I speak and respond. But it's based on a case that the people gave me that they were going to proceed without the complaint. And the statute is going to proceed out without the complaint. So I do not feel that this is surprise because I took what they gave me and read it.
Say that again to me.
There is no surprise to the people, in my opinion. I'm going to make a motion to dismiss because the complainant is not present.
Okay,
And they want to proceed without the complaint.
under 27B,
Yes, under 768, 27.
C.
And just to be clear, it's will be only, I didn't give you any cases, so I've never talked to you about
Well,
this.
maybe
so
it wasn't,
it
was the people. I said,
Just to make sure that I'm personally not surprised. that you have cameras out there.
After his last poop shelf comment, good.
So when I say to people, that's what I do. I'm not.
Right, no, that, I get
Just
you.
like, right? But the people, that's where I got it from. I know who it was, the color. Oh, wait.
Oh, you're welcome to get me mixed up with Jessica Fleischer. That's totally fine with me.
I'm gonna keep this simple and concise, all right?
Right,
All right, based on the complainant's not here, number one.
correct.
She has made statements to the people and the police. She does not want to proceed. All right, but specifically, if you look at people versus own 327-319, that's what we're relying on. Because in that instance, the court did let the testimony in. The complainant did not appear. The court let the testimony in. In that instance, though, the complainant had talked to the police officer specifically. She said that the client broke in, was her ex-boyfriend or boyfriend, however you want to look at it, broke in, demanded money that he had loaned her, took the money, knocked her on the floor and strangled her. The police officer observed red marks on her neck and some other corroboration, I think, bruises on her. Okay, that's totally different. So that is why I believe that case is highly distinguishable from this. They cannot rely on that. So they use the statements that that witness made directly to the officer right under the immediate occurrence of the incident. That's the other thing that's very important. Right after it had happened, because 911 was called right as it was occurring.
I've read it, yeah.
So you didn't have time for reflection, you didn't have time for manipulation, you didn't have time for creativity, fabrication, or any other thing. And that's one of the protections why this goes to 76827C. If you look it up, it's based upon the courtroom, the excited utterance, right? So that's sort of it is.
Well, it's based on that, but it goes a little bit, yeah,
It's
go
based
ahead.
on that the incident, that the statement was made spontaneous or in concurrence with the event or shortly thereafter. Present sense impression as well, the state of mind. That might be a little bit longer, but that's not what the statute is. It's like C. If you look up C, it says there must be a sufficiently startling experience, suspending reflective thought, and a spontaneous reaction, not one resulting from reflection. That's what the C is based on. Okay, that's not here. That does not exist here. They never talk to the complainant.
Well,
That's another point, Your Honor. Could I just ask a simple question? This isn't the unlawful inference, it's just a question.
No,
because it's
I'm gonna get to that. Then I'm gonna tie it up in a minute. I have to say this.
okay, go ahead.
That's what she wants you to deviate to, but I say.
Wants me to deviate too?
Well, I'll tell you, the prong one is not satisfied, the matter should be dismissed. What they want to do is piggyback their case on statements that my client made while he was in prison, or statements the complainant made while they were on the phone. I'm saying this case should come in the first place. So now this would be like fruits from the poisonous tree. It's like, yeah, it would be. It's
Why?
like, I'll tell you. It's
Okay.
like, I had a case once, police said they stopped the guy because he was a stop sign. The stop sign never existed. I proved that with records in the city, right? Therefore, that was a fallacious reason to have the probable cause. Then it was after the probable cause, fallacious probable cause, they said that there was plain view sight of a gun. And after description of the gun, the weight of it, on and on, I was able to show that that search was a fruit of the poisonous tree or the stop. That's exactly what these calls would be. Because they can't come in because they weren't, as I said, she's not here. And she never talked to the police. Now when you get to the phone calls at the jail, that's much further in time away if you were thinking about it. from the date of the incident, which, I believe was August 5th, 2024. So it doesn't qualify under 768.2.7C. It's far away in time, and it deprives him of the right of confrontation under the Sixth Amendment. He wants me to, as I close up, it's a serious matter, it's a real argument. He wants you to leave state on people versus the state Raymond Debarwin. But it is depriving of this right of confrontation. They leave prong one. Now they want to piggyback on the jail calls, which were far away in time and don't need to hearsay exception. They're cited in their case, people are some work statute. The violation, it's real law. It's real law.
Okay.
Constitutional right that does not apply to preliminary exam. The Sixth Amendment is a trial right. I'm speaking now with my daughter. Thank you. Last time I checked, we were not at trial. The preliminary exam is a statutory right. People be only specifically states the Sixth Amendment does not apply at the preliminary exam. I don't know who told Ms. Ford that I'm moving forward under 27C today. This is not a 27C case. And if I had just had the opportunity to ask a question, we wouldn't have had to sit through that entire argument. My question is, at what point in Pittsfield Township Police Report number 24-16611 do you have a victim statement in there? Because the victim statement is what allows somebody to move forward under 27C. I am not moving forward under 27C. This is an assault that occurred on video. I don't need the victim statement for me to play the video of him punching her in the face and slamming her back into a vehicle and then speeding away while she's trying to exit the vehicle. Then he confesses to the officer. So his statement that I will be admitting as a statement against his interest under the Michigan Rule of Evidence is how I'm moving forward. That's not 27C. What's also not 27C is his witness intimidation. While he is in the jail, calling the domestic violence victim from the jail, telling her, call the prosecutor, tell them you don't want to move forward with charges. Did you talk with the officer? What did you tell the investigator? And she says, you bet I did. That's not 27C either. That is also non-hearsay statement against the defendant's interest. I'm ready to go.
Just briefly, as I said, that I've said pretty much what I had to say, that this statement cannot come in independently.
Which statement are you talking about, counsel?
Any statements by the complainant cannot come in without the complainant's testimony in this instance. Or a legitimate.
Hold on, counsel. So I have to make sure we're talking about the right case, because you started out with a 27.3 or 27C argument. But my understanding when I hear from the people is this isn't a 27C case, that there is video and then the defendant's alleged statements that are underlying the primary case. And when I say the primary case, 1055, the unlawful imprisonment and domestic violence
So
there.
the statements were made at the time of the event.
Which statements?
Defendant's statement. He didn't give a statement. And so the statement.
Yes, he did. That's what they just said.
Officer Wilker confessed to the crime. She's going to testify to that today.
That's what I understand.
Hold on, Mr. Epps, hold on. I just want to make sure we're all operating off the same page, because what I understand is, Ms. Ford, hold on, just folks, I'll let you have your conversation. I want to get out what I want to say. My understanding is this isn't a 27C case. That at least what they're alleging, and I've not heard any testimony, so I don't know. I'm hearing what they're telling me at this point is that there is video evidence of the defendant committing certain acts. That then subsequent to that, there is then an admission to a police officer as to those acts or some portion thereof. That's a whole different thing than 27C. And having that. may I also then say, it seems to me that part of your argument was going then to, I'm presuming, jail calls or other things in which the defendant would have said certain things. This is how I'm envisioning this, and I may be slightly wrong in terms of it, that there may be responses from the alleged victim in regard to what the defendant may have said. Again, I haven't heard it, I don't know. But if that's the case, and there's statements in which she may have said, well, and I'm just giving this as an example, I'm not saying it's what it is, that he says something, she says, okay, you're right, I'm not going to show up, or I'm not going to do something, or whatever. That's, and then she's not here, or even actually his act of doing that, depending on what it is, really constitutes the second case. So that's where I think there might be a disconnect as to exactly where this is heading. I don't know, because I'm not involved typically in conversations that council's having. I don't know what may have been told to you by somebody before, but I'm presuming you had the discovery package and could see what was there. So I would anticipate that without the victim being present in this case, that the people would be proceeding with video evidence of these alleged acts, and then the officer's testimony of the defendant's statements. And then if that proceeds, then there's then the stuff that occurred afterwards.
Thank you.
So regarding your motion, I would have to deny it. Do you wish, before you leap over there, Mr. Evans, do you wish to have time to go back and talk to your, that was a lot there. And I don't know, I saw Mr. Epps trying to talk to you first, and then I kind of stopped him and then did whatever, but I want to make sure he has time.
Let that video play.
You want it played?
Yeah.
Oh, have you seen it?
Yes, sir.
Okay.
Stipulation to its admission.
Are you stipulating to its admission?
Yes.
There's, okay, so I just want to be clear, Mr.
My
Epps, you don't
legal
want time to
direction-
talk to your counsel
Thank you,
about what
Fuzzy.
just happened and what I just, because about how they're going to proceed. I get you get the video part, but the other part of it, I don't.
With my understanding, what you're saying, a case is built on the video. I already saw it.
Well, no.
Well,
it's
the
built-
video show this alleged,
Okay, this is part of the problem, Mr. Evans. It's not that I won't hear from you, you know that. It's just that I don't want you saying something that might be used against you.
Oh, no, I know what you're saying, I know what you're saying, alleged.
Okay, but that doesn't always do it. I'm just saying, when you say to me that their case is built off of that, there's another big piece to that, and that's supposedly your statement.
Okay, and I understand that too.
Okay. And then that there is, then that's
House.
that first case. And then there's the next case of what may be, I'm presuming, statements by you on the other case, the bribing intimidation.
And so, I wanted to ask you,
Yes, sir.
I know my Sixth Amendment. It's my.
Hold on. Yes. And here's what I'm gonna do. I'm gonna take a break. Have you taken back? I want you to, because you're asking questions. I could certainly answer them, but I'm not gonna step in between the attorney-client relationship And so I want that question, I want you to talk to your attorney about that. When you start getting into that issue. Because certain things you may think apply at this proceeding may not apply, but I want you to get your attorney's advice. So what we're gonna do is let's take Mr. Epps back, let's get him, and then Ms. Ford, you can go around and talk to him and answer any questions that he might have regarding that.
I want to answer one question. Just real quick. He has not heard every single jail call from me, but he has.
What do you mean?
I read the jail call.
There's a written statement summarizing the jail calls. The bid of voice mail of the jail calls, I guess. He has not heard everyone. I saw him, but they're extremely voluminous. So he is ready to proceed. He knows what the jail calls say. Well, number one, he was on. But number two, there's a summary of it in the discovery. So he has seen all of that, and he still wants to proceed. Is that correct?
Okay, you're still gonna need to ask that other question, answer his question. So I understand that. Can I just say this so we don't run into a problem? I realize he saw a transcript of calls, right?
Yeah.
Okay. Can I just ask, and I don't know whether it's the case, and maybe you know, maybe you don't know. Are those the transcripts that he saw? Are those the calls that the people are proceeding on as part of the case?
Yes, the jail.
Well,
Yes.
okay, I get it. But my understanding is that there are jail calls that he has not heard, but he's read.
Yes.
And that he wouldn't have read all of the jail calls because were all of them transcribed?
Not every last one.
Okay, so then my question becomes, are the calls that the people are relying upon for the case, he hasn't heard any of them, I'm presuming, right? But has Mr. Epsman provided the transcripts of the calls that the people would be relying upon to form the charge?
Yeah, I did talk to the people yesterday. They said they may or may not use any of the specific calls. They may use the summary of the calls.
The answer to your question is yes. Every jail call that I will be using today is in the police report that's been provided to them. I understand he's read that.
And he's read that, okay.
Because we did discuss that yesterday.
Okay, I'm trying to make sure I'm not part of those conversations, so I'm just trying to make sure Mr. Epps' rights are protected. All right, let's take him back, let you talk to him, I'll try to handle the other case, and then we'll come back out and try to do this. Whenever they can bring him out.
All right,
You don't
I'm
have
gonna,
that many. We're just very.
Don't sound like that.
Yes, you do.
Mask.
You sound like.
let's see if I can
Alan
find when
said you
he comes
sounded like a
back.
squirrel that had its tail cut.
Oh,
Just
yes,
saying.
please. Alan, how'd that bus feel as we just ran it over you?
Say nothing, man.
Hi, Mr. Allen. Okay. Is this him? You'll tell me if it's not.
Court does call the case of People versus Cedric Green.
Christina Costantino on behalf of Mr. Green.
All right.
And Your Honor, this is the date and time set for an exam. We have reached a resolution in which my client will tender a no contest plea to second offense and attempted resisting and obstructing. There's also a sentence agreement in that matter for no more than 30 days in jail with a probationary sentence, no delayed or deferred sentencing. I believe no contact as well.
Correct. There must be a no contact order. Is that what you're saying? Yes, there must be a no contact order, but the final thing that's written on here is the defendant must accept responsibility for his circuit court violation or schedule to summary.
I missed that one, but yes, that's correct in our understanding.
All right. And just so that the parties are clear, because I would not be the sentencing judge, I can't bind the district court judge to the sentencing agreement of the 30 days in jail, but I don't see why the court would follow it. But I can't bind that. I can't make that a promise that I'm making.
Understood.
Got that?
We're ready to go forward.
All right. May I have it sworn?
You solemnly swear or affirm that the testimony about to be true, the whole truth, and nothing but the truth.
All right, Mr. Green. This court's understanding that you are going to be pleading no contest to 2 added charges, and I think it's 7 and 8. The 7 being domestic violence, second offense. That's a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court cost. And also to attempted resisting and obstructing, that being count 8, which is a misdemeanor punishable by up to 1 year, $1,000 fine plus court cost. You understand that, sir? All right. Do you understand what a no contest plea is? All right. 2 things about it I have to make sure that you understand. First thing you have to understand is that it means that you're not further desirous or wanting to contest these charges. You understand that? Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? All right. You also understand, sir, that while I'm taking your plea, I would not be a sentencing judge in this case, and you would be sentenced before Judge Perry in the 15th District Court. You understand that? All right.
Do we know
Now,
Judge Barry?
understanding all of that, sir,
Trying to
do you
remember.
still wish to plead no contest? All right. So to the charge of domestic violence, second offense, how do you plead? To the charge of attempted resisting and obstructing, how do you plead? Now, you understand that by pleading no contest, you'll not have a trial of any kind. All right, you signed an advice of rights for the day, is that correct? Do you have any questions regarding any of those rights? All right, on the podium, please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty or pleading no contest, you're giving up those rights as well as all the rights on that form. You understand you're giving up your right to appeal of right. Are you on probation or parole? All right. You understand that your plea in this case could be a violation of that probation. You understand that as such, that other court could sentence you to the maximum allowable under those other charges. Oh, well, do you understand that?
Sorry, Judge, he's a bit confused because we've received a recommendation from probation
Got it.
for the violation of probation. So we have an idea of what he might receive as a sentence in that case. But Mr. Green, you understand that this case will constitute a violation of your probation, right?
Outside of that.
Well, they've already violated him. Your Honor.
Correct.
So you understand that this pleading guilty here is a violation of probation. They've already violated you.
4 days.
Yes.
You got that? Okay. You understand the important part of that is you need to understand that while you've received a recommendation, the court could sentence you to the maximum allowable under that charge.
The circuit court could do so. We've received a recommendation. We have an idea of what the court might do, but Judge Simpson can't tell you today what that court will do. So that court could sentence you up to the maximum allowable under Michigan law. Mr. Green, that's correct. We have discussed that. It's a recommendation. Which is what recommendation.
Mr. Green, let me just say this, that the court, the court always reserves the right to sentence in the way it sees fit, right? Whether it be this court or another court, we have that right to do that. When you receive, we will receive from either our probation department or probation typically, a recommendation of what the court should do. Okay, that happens virtually in every case, right? What I'm advising you of is should that court choose to not follow that, the court could do something else. All right, which could be the maximum on that other charge. It could also be that the court says, I'm not doing anything. It's what's important though is that I apprise you of sort of the maximum thing that the court could do to you. That doesn't mean it will. Just I have to apprise you of that. Now, if you are confused about that right now and you need additional time to talk to your attorney, I'll let that happen because I don't want you rushing into anything that you don't fully understand. So.
That looks like Lisi's kitty cat said hi to John.
Okay, I believe my client's ready to go forward, Judge.
All right. Are you, sir? You think you've had an adequate time to talk with your attorney regarding this? Okay, so I'll ask you the question again. You understand that I understand.
No, look at your keyboard, okay? So the little paw was standing on the T and sort of hitting the 5, and the other little paw was on the B. The kitty cat said hi to John.
And it already has been considered a violation of your probation. And you understand that as such, by the entry of the plea, the court could sentence you to the maximum allowable under those other charges. All right. And understanding that, sir, do you still wish to plead no contest? Has anybody promised you anything other than what's been stated here today on the record, which would be that counts 1, 2, 3, 4, 5, and 6 would be dismissed? Has anybody threatened you or coerced you in any way? You're doing this voluntarily and of your own free will. All right. Court has been provided and has personally reviewed Ann Arbor Police Department report for their case number 24-36705. Any objection to the court reviewing that report?
No objection, Your Honor.
Fozzy's cat, you have other issues that we won't discuss. Overspending.
Thing we don't have, and we can solve that. You do stipulate to the prior domestic violence, is that correct?
Yes, Your Honor.
All right. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Counsel, have I complied with the court rule?
Yes, Your Honor.
Court will accept the defendant's no contest pleas to count 7 and 8. Counts 1, 2, 3, 4, 5, and 6 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
October 2nd at 10 a.m. before Judge Perry.
October 2nd, 2024. What time?
10 a.m.
10 a.m. before Judge Perry. Bond will continue.
Thank you.
All right, thank you. Thank you, Mr. Green. Good luck.
Thank you, Fozzy's cat.
Ms. Constantino, always a pleasure.
Always a pleasure.
Yes. Okay. And
Mr. Allen is going to.
Is he coming back out?
okay.
I thought I saw that lawyer sitting there.
So is this one going?
Is that her? Is that
I
it?
asked Michelle to. Get on your standing. Yeah.
Is this it? Is this the right spot?
They just record for County Washington.
Looks like it.
You may be seated. Okay, are we ready to proceed on apps?
Yeah.
Here we go. Can you bring it up, please? Court does call the cases of the people, state of Michigan versus David Epps. Thank you, sir. Date time set for preliminary examination. Are you ready to proceed?
Yes, Your Honor, thank you.
Sure,
All right.
then go
Can you call
cancel
your first
that.
witness?
Go do it right now real quick so you don't forget.
Take a seat, raise your right hand, and solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. See, say spell your first and last name for the record.
Who are we writing a letter to?
Officer
Officer
Jessica
letter?
Bunker. WTLKER with this department.
Thank you. You may inquire.
Thank you, Your Honor. Officer, Officer, where are you currently? Pittsfield Township Police Department. Thank you. How long have you been employed as such?
Pittsfield, I've been employed there since October of last year, but I was officer.
Prior to Pittsfield, you were with Ypsilanti Police Department?
Yes.
Thank you. Were you working in your capacity with Pittsfield in July of 2024? Specifically on July 28th of 2024?
Yes.
Are you familiar with the address of 5550
Oh, never
West
mind. I'm
Michigan
not writing
Ave?
a letter.
Pittsfield Township, Washington County, Michigan.
Yes. The intersection of Michigan and Carter.
How did you come to be involved in this investigation?
I was on the 11 and inspection myself at McDonald's. Initially based on inspection information, we were dispatched to one a little bit farther up, north on Carter. But based on the
See, your
description of
kitty's
the
attacking your
construction,
keyboard.
we realized now that Sam's level Carter.
So for instance, you had the opportunity to arrive on scene of this McDonald's. When you arrived on scene, was it approximately 2:07 p.m. or around that time?
Yes.
When you arrived on scene, did you have contact with someone by the name of Shanora Harris? To this point in your career as a police officer, how many times have you interviewed Shanora Harris in person?
I knew Ms. Harris from Ypsilanti PD, so I can end up there, but as far as interviewing her on facts in this case, I didn't.
Thank you. Did you make efforts?
Yes, I called her to verify.
Okay, Slytherin.
Or to talk to FaceTime to speak with her about things and she.
Thank you. When you arrived on scene of the McDonald's on July 28th, 2024, did you have the opportunity to speak with witnesses? Specifically one male witness?
Yes.
Without telling me any of the information that he told you, did you also have the opportunity to speak with staff members at the McDonald's?
I did.
When you spoke with staff members at the McDonald's, did you make any inquiries about Shanora Harris? Meaning, did you ask them any questions about somebody named Shanora Harris?
No, it was presented to me.
Thank you. Did you have the opportunity during your investigation to look into surveillance footage? Why?
Excuse me one moment. Can you call Mr. Banner? Go ahead.
Same for me, Tokyo. Different
Why
browser,
did you look
different
into
account.
surveillance footage?
Based on the allegations, and without looking
correct statements made by the first assault allegation. Okay, therefore, I requested surveillance footage of the business on the outside. However, the alleged incident was also happened and was able to obtain. Did you understand Shanor, employee of that McDonald's? After interviewing some of the other employees, yes, that information was provided. And did you have the opportunity to review surveillance footage from that McDonald's as it relates to
We never would have figured that out, Tokyo. Never.
July 28th, 2024? Yes. When you reviewed the surveillance footage, where were you initially? Reviewing the footage, I went to the location with one of the detectives. Reviewed the footage there. The employees who gave input, which is what led to the identification of Ms. Harris, as well as after the fact. Were you present when the video was being downloaded or extracted from the McDonald's? Yes, I was. Thank you. Your Honor, I am plugged in. How do I get connected to this?
Try incognito mode.
You are connected.
Thank you very much. Officer Walker, can you see the screen? Yes, ma'am. Are you familiar with what is presently on the screen? Yes, ma'am. Could you please describe to the board what this is? Of course. This is a full cam that faces the parking lot of the 5550 West Michigan Avenue McDonald's at intersection of Carpenter Road and Michigan. And the screen that I have it stopped on, have you had the opportunity to watch the video from this point forward? Yes, ma'am. And is this a fair and accurate reflection of the video that you took into evidence as part of this investigation? Yes, ma'am. Your Honor, at this time I would move to admit People's Proposed Exhibit 1.
Any objection or voir dire? Okay, and I've already ruled on that. Is there any objection to this piece of evidence coming in? Exit. So that the record's clear. I've already denied that, so I hear no objection. Exhibit 1 is admitted.
May I just place on record to say more that it would be a continued objection? I want to say.
And my ruling will be a continual one of the denial. Go ahead, Ms. Hughes.
Your Honor, may I have the-
Yes.
Incognito mode does not work, by the way. I just tried it on a different account in a different browser.
Understanding of who the person is that was dragged and put into that vehicle? Yes, ma'am. Who is it? Nora Harris.
Your Honor, I would just like to place an objection like a foundation to identify who either person was in that video.
Certainly, I can later.
Yes, go ahead.
Did you have the opportunity to interview somebody by the name of David X? Yes, ma'am. If you were to see Mr. Epps again, would you recognize him? Of course. Is he present in the courtroom today?
Yes, ma'am. He's sitting sitting next to his counsel. That's
Thank you. Your Honor, please let the record reflect the witness identified the defendant.
Without objection, record shall so reflect.
Did you have the opportunity to interview the defendant?
yes.
Where were you when you interviewed the defendant?
It's not so much which department you want.
Interview was the defendant in your custody at that time. Prior to the interview beginning, did you read him his Miranda rights?
Yes.
How did you do so?
I remember right over and I review them, decide next to individual rights as well as one best if you have enforced like driver in any way.
At the conclusion of reading him his rights, did you understand that he was waiving his rights and wished to give you a statement?
Yes.
Did he give you a statement acknowledging that the person that was put into the vehicle is Shanora Harris?
Yes.
Did he give you a statement acknowledging that the person that put her in the vehicle is David X?
Yes.
So going in order of his statement. So first, I apologize if you already said this. Did this interview occur on August 1st, 2020?
Yes.
Thank you. At the beginning of your interview, did you indicate what you were there to speak with him about?
Yes.
At this time, when you started the interview with him, did you know Miss Harris's whereabouts? Did you have any concerns about her whereabouts?
And then,
Could you tell us about that, please?
Yes, go ahead.
starting with the timeline of the incident, if that's all right, I'm explaining the foundation for it.
Thank you.
The incident happened on July 28th, at McDonald's, and that was the last time that anybody had, got something. We had her on camera, and that's the last time anybody said that they see. According to Mr. X's statement, he claims that that's the last time that he saw her, and they got into a conversation verbally, and then they really not. After that, on the 30th, her items, her social security card, various items ID were located on the scene of shooting in International. And we didn't find her.
May I interject one thing? Does she have a statement where it's sworn, in his handwriting, where he's written that and he's signed it?
No, ma'am, it's on camera in my area.
I'm going to discontinue it.
What are you objecting to, though, counsel?
I haven't gotten any ads.
I don't see a signed statement of him. But I know I don't see a signed statement. So that's.
Okay, but have I'm sorry, the interview or statements that you're relating are on video.
Yes, Your Honor.
Have you been provided a copy of that video, counsel?
Yes, I got discovery, it didn't all pop up. That's
Well, what does that mean?
some of them pop up, the pictures pop up and some don't. We like push to see various parts of discovery, some pop up, some don't.
Okay, but here's my question. With reference to the statement that the officers testified, which you're objecting because it's not in writing, did you receive, you have what?
I have some of it right here.
Okay, I understand that. But did you receive a copy of his video statement?
I got to discuss.
Not my question, counsel. Did you receive a copy of the statement?
Yes.
Has your client had an opportunity to see that statement?
Yes.
Okay, I can't.
Oh boy, breathe through it, Judge.
Let me ask you this, because otherwise we're going to run into this at every stage. Has a discovery that you received, has that been shared with Mr. Epps?
Not all of the videos.
So what videos haven't been shared?
I saw the one, that you did like,
Okay, got that. So there's a video of the statement.
But I did not show him. But he knows it.
Michael
terms of
wasn't
the
here.
business record, but not the
Michael was
videos.
not here.
Just, I get you. Just stop. So, counsel, you can't, the officers up here testify. You're objecting because the statement isn't in writing,
Right.
but you're not objecting to at least the substance of what she may be saying.
That's correct. Before we got started, I did mention to my client that certain videos that I've seen, I asked her.
But hold on, counsel, I'm gonna stop you. I'm gonna stop you right there. When we were going through your previous argument, one of the issues that you were trying to say it was a 27C case that Ms. Hughes specifically brought up was your client's statement. And so if you
Crystal,
knew,
thank you so much.
counsel, don't you think your client should see what he's telling me? He doesn't have any idea that it was recorded. I don't know if that's true or not. Doesn't matter. Because the thing is that clearly that's evidence against him. Would you not agree that he should at least see that? He may not like it, he may not whatever, but he should at least see it. Not right this second. I'll hear it from you, but just not right now. Okay. How long is the statement? An hour.
At least the recording.
Right, but the recording of his interview is, okay, all right, hey. What do you want to say, Mr. Epps?
I didn't have no knowledge, and I don't think she had no knowledge of the video. This is just coming out today. That is a
Had no, say that second.
knowledge of a video. This is just coming out today, sir.
Well, hold on, I don't mean, I want to make sure I'm understanding what you're telling me. I hear you, that you're saying you did not. And then you're saying that you don't think counsel did.
No, but this is just coming out today that it was video.
I shared a video with Miss Ford on August 9th, 2024, and it was downloaded, and she still has another 52 days left if she wants to download it.
Go.
No, that, yeah.
Sorry, Your Honor, may I approach the witness for just one moment?
You may.
Thank you.
So. I don't know that I can. Mr. Epps, I don't know where I can answer your question, the second part. I hear what you're saying, but I don't know that I can answer that. All right. The only thing I am concerned about is Ms. Ford. Whether you knew about it or not, because I don't know, and I'm not going to get into that at this point. Wouldn't you believe that at a minimum right now, as we sit here right now, that your client should be entitled to see that video?
Yeah.
Folks, officer, you may step now.
Thank you.
All right, I'm going to adjourn this. I want every Miss Hughes, you indicated that that was sent to council.
Yeah.
All right, Ms. Ford, do you still, hold on. Do you still have a copy of that? All right, but no, just stop. That video is to be shown to Mr. Epps. Now, how many other, Mr. Epps, you said you saw the one that we just saw, right? All right. How many other videos were sent?
16 videos were sent and 4 pictures were sent.
So 16 videos, 4 pictures.
Yes, separately, there are jail calls as well that are, I sent directly to her by email.
Okay, I'll get to that that's on the other case. All right, so Mr. Epps, let me ask you this. Of this, I'm just trying to think of the correct way to phrase it. How many videos did you review? Let me put it that way.
I reviewed the one that we just saw, and I heard phone, recording.
Hold on, I don't want to get into phone recording. I'm talking just about videos right now. How many so what I'm hearing from you, you've only seen one?
Yes, sir.
Okay, so that's. He's got to see the other ones. Some of them may not mean anything at this point, but certainly if they're proceeding on his confession, then he's got to at least see that one, but he should see all of them, or at least have the opportunity to see all of them. Those videos all relate to the case ending in 1055. Is that correct, Ms. Hughes?
Yes.
Okay. Now, there are also, and we were kind of getting into this before. He's seen the transcript of phone calls, but Mr. Epps, I'm going to ask you again. You haven't heard the calls.
Yes,
Pardon?
yes.
Okay, I asked the question badly. Have you heard any of the calls?
Some of them.
Okay. The ones of and you may or may not know this, the ones of the transcripts that you read, did you hear those calls?
Yes, some of them.
Okay. But you haven't heard all of them. So let me ask you this. Is there some of those calls that you're reading what the call said, but didn't actually hear the call?
What's that?
Was that correct, what I just said? Okay. Okay, so Ms. Ford, how many, I don't know, I don't want to put it that way. Is there a reason why the calls themselves have not been provided to Mr. Epps to at least hear?
None other than I saw him and I told, their calls last for hours and I told him they lasted a long time. We discussed what they said, but other than that, no.
Okay, so let me ask this. I realize the calls may last for a long time, but and so that there may indeed be calls that he just doesn't need to hear. I mean, whatever, because they're not going to really be part of the case. But has he heard the recordings or had an opportunity at least to hear the recordings of the ones that are transcribed?
No. There's about 11 of them. No.
Okay, there's about 11 calls. Is that what you're telling me? while it may or may not be important, those 11 calls, the transcription of those 11 calls, are they accurate?
I believe so. I believe that. The client can't say because he hasn't heard the direct call.
As to the calls, because we kind of dealt with this earlier, Mr. Epps. Mr. Epps, did you want an opportunity to hear those calls and to attempt to try to verify those calls as against what you read?
I wanted to call playing in court, but
Well,
Goodness, no, please.
do you know what they say?
no.
So let me ask you this. Why would you want them played if you're not sure what they say? And I'm just saying this, let's say what you read is not what's on the call.
Yes, sir.
Why would you want that played before you can hear it yourself as to what I'll hear?
Sir, I'm currently on the road right now.
Right.
And I had they have an evidential hearing before you go to your immediate, your hearing,
An evidentiary hearing before you go.
to your immediate hearing.
Right.
The charge, the charges that I'm facing. So, the cause is really vague.
Right, okay. Stop. Can I just stop you there?
Yeah.
Right now? Because you're not gonna have that type of evidentiary hearing before this proceeds. I see why you say you want to play in court. I get it. That's not the way this procedure works. Okay, so if you, and what you just said, that you think the calls are vague and may not mean what they mean, it's going to be important, frankly, for you to hear the call. I would agree with you that sometimes on paper, something can say something,
I don't agree with that.
but
Public
be said in
defenders
a
work
way
hard.
that that's not really what's meant. I think that's what you're trying to tell me when you say vague. Is that right?
Vague, when I say vague, meaning that you can't hear it, like you can't hear.
So they're faint.
What's going on?
So
And maybe.
hold on a second. When you say that, what's on the paper that you read then about the call? If you can't hear it, huh?
Yeah, you like, when I'm doing my interview, my parole interview, they play it on the screen.
Hold on. You're at another hearing I'm not part of. So were these phone calls part of some other hearing?
Yeah,
Okay, so at some point you heard them?
yeah. But it was, like I said, you barely can hear them, you know what I'm saying?
So in other words, hang on, I got you. So in other words, some of you have heard, but you're not sure then what is transcribed is what the written part is what's on those tapes,
Yeah,
which is why you wanted them played, because you think, okay, I got you. Not a good way to handle it, but I got what you're trying to tell me. All right. You
How
can't-
did he figure
this
all that
can't
out?
go this way.
He's great.
So he, even if one were to say that he doesn't need to hear the phone calls, and one might argue, well, he's part of the phone call, so he knows what they say. I mean, maybe that argument could be made, but there's going to be no excuse for him not seeing the videos. None. Seen all of the paper discovered against you, Mr. Epps?
yeah, sir.
Okay. So I just wanted to make sure. Okay. So here's what I'm gonna do. I'm gonna adjourn this case to October 8th. Council, I don't care how you have to do it, what configuration it needs to be done in, or how you need to arrange that with the Washington County Jail. But you are to arrange so
Pennsylvania.
that if you got, I don't know how long these videos are. But if there's 20 hours of video, you're gonna sit there 20 hours and make sure he has access to those videos and can see them. As well as that he has access to the phone calls. I am not going to accept as some type of an excuse that there might have been some difficulty with the jail or some issue in terms of that. I'm not going to accept it. If you gotta sit there all day and night till you get in to see him, you're gonna sit there all day and night till you
Which
get
is
in there and
close to
see him.
Pennsylvania.
And he gets a chance to see it. He may not even like what's on the video, and that's fine, but he should at least see what's being used against him.
I would like counsel to withdraw, please. I went over it several times with her, about this video.
Knew that was
And like
coming.
she said, she complained that the video was long, you know. I knew it was appropriate to see this video, and I asked my counsel several times, could we see this video? Could we go over this video? I also told her the proper way to let me see the video, that she will have to bring a laptop in, because I've been through this before with a prior, counsel, you know, and it's just like, right now, I'm embarrassed, because it looks like my case is just all over the place, me and my counsel, like, we weren't even ready.
I didn't complain it was on, but he's right, I didn't bring in the laptop. One time I did, actually, one time I did.
Maybe it is Boston, Wisconsin. I always get those two mixed up. The judge wants to allow the
You
withdrawal.
understand if I do that, Mr. Epps, that this would further delay your proceedings.
Yes,
You understand that that's a possibility, that it'll be further delayed.
I don't want no delay, so I guess I'll just go ahead with counsel.
Well, Mr. Epps, I wasn't trying to lean you one way or the other. I'm just trying to.
Your Honor, we just came in here.
Mr. Epps, I'm hearing you. Okay.
He hasn't seen all the video discovery, there was a firm plan I found.
Pardon?
The gist of the plan I have found, he has not seen all the video discovery, that is correct.
I'm acutely aware of that. Today is what? Well, all right. Let's do this. Let's take Mr. Epps back. Mr. Epps, I'm going to think about your request and that whole issue of delay and see that. Give me a minute to try to make a decision on that, okay? Because it's.
So one thing on your radar is continued use of the jail calls, just to put the defense counsel on notice that I will be addressing that when we get back.
You will, what?
He has continued to call victim of the jail.
I just found it.
Oh, okay. Yeah, thanks, because there wasn't enough on my radar. I do appreciate it. I do appreciate you.
Like the cliffhangers.
Court's gonna stand in recess.
Oh my gosh. Watch. This is one of those ones where he doesn't come back. Private. Oh, no. Woo, he came back. He does that. He doesn't come back sometimes and you don't get an answer.
Then I got caught up.
I mean, I never see. Thank you for your time. We talked a lot. And, mostly I'm amicably. And at this time, I do not believe, we both went back on this matter, whether that actually is lawyer, in my opinion, if we both went back and forth. But in this last 10 minutes, he told me he thought it was best that I not be on the case, and I'm just going to agree. This is the first time I've ever withdrawn, ever, since the middle of law school. But I think the defect can be cured with the statement and the discovery. That can be cured. I could stay there 2 or 3 days. That's fine. I think if I can't win, that's not fine. I think if he gets blocked on that flow, that's very fine. And I cannot promise a blueprint and battle plan on every question he has, and that's what he is very intelligent. That's what he wants, a battle plan. When I say I think, that's because I know the various ways of matters can go. To him, that's weak. To me, it's insightful and knowing very a bunch of nuances and not promising something's gonna go one way, when I know good doggone well, it can go sideways, or it can go in another direction. So I have a difference in style, that doesn't meet that right there doesn't meet his need. He needs a battle plan, someone say, like, start to just win this war, period. Whether we win it or not, that's not my style. So between all those reasons, he deserves what he wants. There are lawyers that will do. He deserves it.
All right. Thank you. Yeah, well, let me just say this. Sometimes I think that, having been a practicing attorney myself previously, that I think sometimes clients have a greater expectation. And I think that's what you're getting at, Ms. Ford, about things. And about what can happen. Having to apprise the client of the particular risk. And then saying that something is going to go exactly along a certain lines. And that's not the way the law works necessarily. And I think, in all honesty, when I assess it, when I look at it, that neither you two just aren't good for each other. And it may be because of what Ms. Ford says, that you want something definite. Just in the little bit that I've listened to, that's not going to happen in this case.
I had a nightmare last night that 4 of my cats all had kittens. It was terrible. It was not a good thing.
Right. But maybe you could then maybe have closed the gap between each other had you looked at everything. Maybe not. Maybe you still wanted it to go a particular way because you got a lot of risk here. And maybe sometimes, I'm not saying that you've done this, but sometimes clients get locked in that they want this resolved. And regardless of what you're looking at, that happened, that you're looking at it, but you're not seeing it. Okay. So I don't think all of that matters. I'm not here to try to attribute blame to anybody or anything along those lines. I just have to, my job is to try to make the proceeding fair, regardless of whatever the outcome is. I just got to make it fair. So, yes, Mr.
I'm just saying, if you're telling me if you're telling me, you can do such and such, and I ask you to show me that in black and white what the law says, I expect to see that, sir.
Yeah, but Mr. Epps, it doesn't work that way. That's partly what I'm saying. I can sit there and show you something that is black and white in the law, but what people don't understand is whether or not that black and white that you're looking at is going to apply is going to depend upon what the facts are that are leading up to it. And so sometimes it may look like it does, that it applies, but it doesn't apply. And there are reasons why, and some of them are very nuanced reasons as to why it doesn't apply. If it were as easy as what you said, we really don't need lawyers. Because I could just, well, you don't need anybody. I just put these facts into a computer and say, this is the result. That's not how it works. And it doesn't work that way for a reason, which I won't necessarily go into, but you know, all cases have their nuances and their little pieces to them. One change in something can change the result on the other end. It would be, quite frankly, in a lot of cases, and I won't say malpractice, but it would be wrong for an attorney to say, here is the absolute result.
Not saying it'll be false, I'm asking her to show me how to law. I came to her, sir, and said, I got the right to face my accuser, sir. Here it is.
Right, but can I just say that? Can I just say this? You're right, you have the right to confrontation, but did you hear the case law that applied? And that is, hold on, because that's what it says. But then there are certain instances where that doesn't apply, like a preliminary exam. I mean, and there are reasons behind that. And, you know, everybody wants a simple answer, but it's not always a simple answer. It's just, that's just the way it is. But I'm going to give you your wish, and I'm going to give you Miss Ford's wish.
We're also dealing with love, I believe. And it's hard for most defendants to concede that there could be a conviction if a complainant doesn't want to go forward. It's inconceivable.
I know.
In the law is nuanced in this, especially in this area. And I feel I'm up against a brick wall kind of at the end of the day that I might not be able to make it black and white. And I'm sorry to leave this.
And no, but here's the thing. Here's the thing, Ms. Ford. And this is again what a lot of clients don't understand. They're looking at something in black and white. They get what it says. And I think you're right. I think Mr. Epps is very intelligent. And he sees what it says. The problem is, and some of this doesn't in some ways make sense, but when you read that, that's not what it necessarily means by just the ordinary thought of what you're reading. It may mean something different, and then it means something different depending on what part of the proceeding you're at. You know, like, yeah, you say you have a right to confrontation, but guess what? You don't, at an arraignment, you don't have that right.
I understood that once the prosecutor said that.
I said it all last night, and then the other time, oh my God, it's time for me to go. My time is, oh my God. Let's move on.
All right.
I'm not here to argue with her.
I'm not here to argue, but I'm here to clarify. So before I can do any more clarification, I think I should
Just everybody just hold on. Everybody just have a seat. Mr. Epps, please. Miss Ford.
Contempt.
So
Get her.
here's what I'm gonna do, Mr. Epps,
$250.
because this is your proceeding. I'm going to, on the court's own motion, that way I'm not granting your motion, I'm gonna do it on my own. I'm gonna give you new counsel. I'm gonna relieve Ms. Ford of her obligation in the case. I'm gonna give you new counsel. It won't delay it, because that was the other issue. It won't delay it any more than what I would have had to anyway regarding the discovery issue. So it'd be October 8th, 2024 at 9 a.m. before me. I would just caution the people that while we've taken some testimony, because new counsel's coming in, and just to be fair, that we'll probably start just start over. We didn't get that far in on that. And the court, and I'm going to sign the order later, but I'll order it now, that the court will appoint David Burgess to represent you in this matter. He's already aware of it. He's already aware of the date. So he may, knowing him, he'll probably, he's tied up in court, otherwise he would have come down. I'm sure, knowing Mr. Burgess, he'll get to you. So when he shows up, don't think that it's maybe somebody you don't know, but that's him. Okay, but he'll be down to see you. Okay, and at this time, Bob, thank you. Yeah, no, just have a seat, Miss Ford.
Contempt of
No,
court,
no,
$250.
we're done. I'm done, Miss Ford, I'm done. I'm
Get her,
so
Mr.
done.
Allen, get her.
All right, is that it?
Yeah.
All right. 14A stands adjourned. Thank you.
Okay. I'm not gonna play the other Judge Simpson.
Thank you, Miss Hughes,
That
as
one went
always.
for so long. But I am going to, I have to play some Judge Fleischer because I have it in my thumbnail. So here we are. We are on Tuesday. Is that right? I don't remember what day this is, guys. I think it was Tuesday. Yeah, you know what? I'm just gonna go with Tuesday. And you guys can correct me. I'm gonna fast forward it to about here. Nope, there's nobody there. Here we go. I have to be somewhere in less than an hour. So we can only do a tiny bit of Judge Fleischer, but you can always go to his stream and watch the rest.
I have a defendant here that we need to talk to.
There
Okay,
we go.
guys, we'll reconvene here momentarily. Thanks, Michelle. No, you can stay in here. No. Don't go far.
That was a great Simpson video. Yes.
Mr. Romero, how's jail? You're on felony probation for injury to a child, which is a very, very serious probation, and now you picked up an evading arrest. I have no idea what happened with the evading arrest, so we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Alienation.
Okay, please, Alex.
The evading arrest. On September 15, 2024, officers observed a group of males trespassing in the closed section of a strip center while on patrol at 5900 South Gessner Road in Harris County, Texas. The officer was aware of no trespassing affidavits for the strip center and also observed no trespassing signs posted outside the strip center's door. Officers made contact with the group of males and informed them they were trespassing. The defendant informed the officer that he did not have his ID, and the officer observed the defendant to be nervous, sweating profusely, and shaking. The defendant stated his name was Alexander Ramirez with the date of birth of August 31st, 2003. The officer attempted to detain the defendant, but the defendant pulled away from the officer and began to evade on foot. The officer pursued after the defendant, giving verbal commands to stop, which the defendant refused, and he continued to evade through 2 parking lots. The officer
I feel very guilty talking about Mr. Allen when Stephen is right around the corner.
lost sight of the defendant and established a perimeter. A witness informed the officer that the defendant was inside a gas station restroom. The officer approached the restroom and observed the defendant inside. The defendant evaded for approximately 340 yards. The defendant was ID'd with a booking photo.
Okay. Real quick, can you give us a brief rendition of what happened in the injury to a child?
Yes, Your Honor.
Armin, are they unopposed?
Yes and no.
Okay.
I
just want to know, okay.
Yeah.
I was going to try to get you out of here.
So briefly, it says on April 19, 2024, an officer was dispatched to a family disturbance and met with the complaining witness and the defendant's mother. The complaining witness and the defendant are brothers. The witness advised that she observed the defendant on top of her 12-year-old son, punching him multiple times. The complainant advised the defendant attacked him when he told him that to not eat the food on the counter. The witness advised that she feels that the deed will kill her because he has anger issues. So he attacked the 12-year-old.
Mr. Romero, Who do you have that's gonna take you in? Who do you have that's gonna take you in? Am I speaking Swahili? Who's gonna take you in out of the
Maybe.
cold, off of the streets?
I don't know.
Mr. Romero, I'm trying to find you a place instead of the streets.
I don't know.
You know, you're not being very helpful here, but if you can't talk to me and let me know who you have in your life that's ready to take you, I have nowhere else to put you back into custody. Okay, let's do this. I'm gonna have you speak with Jillian. I have appointed her to represent you. We're gonna try to reach out to your dad to see if he will take you. I'm not gonna release you just to put you out on the street. That's setting you up for failure, and I'm not gonna do it. If we can't find you a place to stay and something that's stable, then I'm gonna keep you with me. One more thing. If I test you for dope, what are you gonna test positive for? That's it. Okay. You please do me a favor and see, let's talk to dad and then craft a plan because it's going nowhere real fast. Okay. All right, Mr. Romero, we'll talk to you shortly. Hey, you ready?
Yes, Your Honor, I have two pleas. Both of them are Spanish and I have Luis
Okay,
here.
Luis, you ready? Okay.
Louise,
Vámonos.
goat Louise.
One, both, Judge.
Goat Louise.
Yeah, let's do them both. Come on.
Oscar
It's
and Noel.
another goat Louise.
And then the gentleman in the box, I believe needs bond conditions after this, Judge. He's also known as I have Luis.
Hernandez is through to last.
Whoa, hold on. So is this,
Other goat
okay, Oscar,
Louise.
3-2? And who's the other one?
Castro.
Castro.
Maybe dates with 2 days added and it has been.
I don't know if we see Pavel in today's stuff, but this would be the last time we play Pavel because we start a new week in a couple hours, and there's no Pavel anymore. So this might be the last we've seen Pavel. Also, on a separate note, Linus and Maiko, I gotta take my cat to the vet. I took her to the vet last week, and the vet wasn't there. So I'm doing it again. I gotta be there in 45 minutes. So I might be late for Judge Fleischer, depending on how long it takes. Well, there you go.
Date on Castro this Friday, September 20th.
This Friday. Okay. 30 days, you said 2 days credit, right?
Yes.
Okay. Gentlemen,
Señores.
both of you are charged. Well, hold on. Who's Castro Gonzalez?
Gonzalez.
You are Oscar Hernandez. Both of you gentlemen are charged with driving while intoxicated. You are facing up to a year in jail and or a $4,000 fine. Both of you gentlemen are making lifetime decisions today where you are pleading guilty to these cases and they're
I
going to
had
go
no
on your
reason to
record.
think he wasn't gonna be there.
You,
I have an appointment.
Mr. Castro, have a lot to lose. How old are you, sir? You're 30. Now this makes 2 DWIs that are going on your record. What happens on the next one?
I would be deported.
Yes. What else?
My record would be damaged forever.
You will be looking at a minimum
Simpson,
2 years in prison, a maximum of 10 years in prison. And all that has to happen is that you have the faintest smell of alcohol or dope. This has 2 DWIs. So if you ever get pulled over, an officer is going to see DWI, DWI, the faintest smell of alcohol. And this applies to you as well.
Order in the court.
They will see this DWI that's going on your record today.
Sorry,
They are not going to cut you any slack. The mere smell in and of itself, they're going to arrest you. They're going to put you in jail. And now you're looking at a ton of time in prison. Do you understand? I would never, even if you've had a sip of alcohol, get in a car and drive. You have worked out an agreement. They're offering you 30 days in jail, credit for the 2 days that you've done. Mr. Hernandez, you've worked out an agreement. They're offering you 3 days in jail, credit for the 2 days that you've done. Is this how you understand it, gentlemen?
Yes, sir.
You
Usted.
must turn yourself in this Friday by 6 p.m. If you fail to do it, I will issue a warrant for your arrest and I'm going to have a contempt hearing and you'll be facing an additional 6 months in jail. I want you to understand, I'm giving you the courtesy of turning yourself in, but I expect you to turn yourself in on time. Mr. Hernandez, you will not be doing any jail time, but the next time you come back, it is a minimum of 30 days in jail, which is what he will be doing now. Do you understand?
Yes.
Both of you are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty or undo this, the record is the rest of your lives. Shh. Do you understand?
Yes, sir.
Plead to the offense of driving while intoxicated, second offense, Mr. Castro. Guilty or not guilty?
Guilty.
I will find you guilty. I'm going to suspend your license for a year. Do not drive. Do you understand?
Yes, sir.
How do you plead to the offense, Mr. Hernandez? Do not drive. I am also suspending your license for 90 days. Until you get a license, if you come back here, you will be doing at a minimum 30 days in jail. Do you understand?
Yes.
All right, guys, I'm gonna have you meet with the clerk and then good luck to both of you. Oh,
Meet with the clerk. Rude.
is it true? Hold on a second.
Melissa. I'm gonna need someone to remind me. I have to get.
Mr.
Judge
Castro, is it
Simpson
true that
on
you had a
November
prior
6th.
UWI here in
gonna remember.
2023? Right, true to the enhancement. All right, guys, good luck. Thank you. Okay, Armin. Oh, I'm sorry. He had one more thing.
Martinez Torres in the box, Judge.
Come up, Mr. Martinez Torres. What do you guys want to do?
Hi, Linus.
I just got a wreck today. It's a time served offer, but I can't.
I got it, but I'm putting an ankle monitor on him today. This case is old. He's taken off on us 3 different times. The next time you take off on me, I'm going to quadruple your bond.
I said that to many
At
men.
some
It
point,
didn't work.
someone is not going to pay the money for you and you will be stuck like Chuck in jail. You take off on me a 4th time, so help me, 4 times goes your bond. Do you understand?
Yes, sir.
As it stands now, because I can't trust you, I'm ordering you to obtain an ankle monitor now that you're going to put on. You must remain in communication with you. I will give you 30 days. At that time, you must be back here ready to accept the offer from the state, or I'm going to set your case for trial. You understand?
Yes,
All right, good luck, guys.
Thank you.
Thanks. Okay, sorry about that.
Hey, Judge.
Hey.
All right, so here's what happened. This is an old case that was no PC, got dismissed. The state filed a motion to destroy the weapon. You signed that order. I filed a motion to return the same day. You signed their order. So the only reason they're opposed is because you've already signed their order, but I'm asking.
You okay if I unsign the destruction order?
Well, Judge, it's already been signed as of yesterday morning, but.
We had no idea at that time that he was going to file a motion for return, right?
He already filed it.
Right, but I mean, would you have been okay at the time had he filed a motion to return? You know?
I would have needed to look at the ownership of the gun, but that's, like, we haven't established that yet because we already saw the destruction order. So we were approaching the court on the destruction order. I don't know who owns the gun, so I need proof of ownership as the court owns it.
Right, so I can unsign the destruction order, okay?
Okay.
And then
And then
just
they can look up
go to
ownership.
right. Well, no, who wants the gun?
My client wants the
Okay, we need to know that it's his gun though. So if he can provide some kind of proof saying, hey, I bought the gun, and then that's all we require, just to know, so that if I give the gun back, I know it's his gun and it's not someone else is gonna come out of the woodwork, hey, man, you gave me my gun, because it's happened.
Right, yeah, but the state took it from him.
My gun.
The state should return it back to him. I mean, regardless of owning.
As long as he owns it, I agree with you. Yeah. I don't have a problem with that. I'm okay with that. But as long as it's his.
Mr. Allen is no Lori.
What's your cause number, Armin?
It's 240, I think 3298.
3298, yep. You got it.
On Moncrief.
Yes, sir.
Okay. Did you get the cause number?
Yeah, I'm working on the set.
So this
Okay,
was the
we're
day
gonna have to do a
after
set
his
aside.
purple outfit.
And then I'll sign it.
That may be
We'll set
blue.
aside the order. And then it'll
Whatever
just
day
kind of
that
be in limbo. And then whenever you get the docs, just bring it back, show it to us, and then we can grant.
Okay.
You know?
I'm texting him right now.
And I'm assuming that if you're unopposed, right?
Yeah,
I need to know your position as well.
Sometimes we get some good ownership documents.
What is that on your finger? What is that? Did you just get married for real? And you didn't tell anyone?
Yeah.
I mean, come on, what the hell is wrong?
To get out of everybody.
I mean,
What is that on your finger?
Well, congratulations.
That's all.
really? You tell no one? Well, congratulations. I mean,
Well, I'm saving up for the ceremony, so it's hard to describe like, oh, I got married, but the ceremony is next year because I don't have money for it yet.
So you eloped.
Yeah, I love this exactly.
we're like a family, man. We're supposed to know this.
Yeah.
You know?
Yeah.
So, hi, I brought Vicky as well, because she's, well, if you want.
Like you guys would tell me before you get married, right? You guys just wouldn't come into chat and say, oh my God, I got married last week, right? Because that would hurt everybody's feelings.
So, I'm playing catch up because obviously I wasn't here the last couple of minutes on the approach, what already happened so far regarding the motion to restore property.
Sure, state filed a motion, I filed a motion the same day, judge signed state's motion.
Wait a second. Are you opposed to it?
Yes, for a number of different reasons, the most immediate of which is the fact that when the motion was filed initially, a notice was sent out and it was signed and there was no objection from the notice that we gave for the original motion. And so unless there's a legal.
No objection by who?
Where was the one?
Moncrief, by.
So
I want to hear him pronounce Lancaster, Worcestershire sauce, Walmart, iron.
Armin, understand, like I get, because there's so many documents and.
I know, Judge, I'm not faulting you, but in fairness, I am still his lawyer on this case, and I was never served with documents.
Did you represent him initially on the gun case?
I did.
Okay, all
But
right.
this was sent after the case was dismissed. It was signed on February 18, 2020.
And that's fine, but the obligation to
I'm not
the
surprised.
client and continue representation doesn't end on dismissal. We know this. It doesn't end on a guilty finding. It doesn't end on dismissal. I'm still attached to the case. They didn't serve me with the proper documentation. I'm still the lawyer on the case. I've never stopped being his lawyer.
It was Mr. Moncrief. So I spoke with Brian on the way here. Since it looks.
Look, I'm not gonna make an immediate decision as it is now. If you need more time, take more time, because he has stuff that he has to do regardless on this case as well. So we can reconvene in a couple days. You get your ducks in a row for your argument that you want to make, and you get your ducks in a row as well, and then we can have a hearing on it.
And I want to make sure, because I only caught half of it, is that he, the defendant, is claiming that the gun is his. Because from what we have from the case and from the documents here and with the information on the gun is that we believe the gun is owned by someone else.
This is why, before I ever grant any motions to return, I, as a matter of course, require the person requesting the gun to show me proof that you actually bought the gun with like some kind of receipt, serial number. You know, like if you buy it at Academy, they'll give you a receipt with the serial number, yada, yada, because it's happened to me before where I've granted one and it belonged to someone else. And I don't ever want to do that again. So, but I don't know their position. I want to give them time to do their diligence and you time to do your diligence. If you think it's someone else, then prove it.
So because the
And
case.
if you think it's, if Mr. Moncrief says it's his gun, prove it. And then if he can, I mean, typically they're unopposed because it was dismissed, right? They have no right to the gun. Right?
So because it isn't one with active cases setting on it, is when does the court want us to reapproach?
I don't care, whenever you want.
Well, just so we know to be here.
You guys tell me when you want to come back. I'm in no rush. I'm just burning without an air conditioning unit. That's it.
Yeah. 2
Oh,
days. Good
Judge.
enough time frame?
Sounds
If
Thursday?
if you need more, you can have more. There's no rush.
I think you're cool, Judge. Yeah.
So,
Sounds good.
okay.
2 days.
So what's today's Tuesday? So let's reconvene on Thursday and then just let us know. Now, Day,
Well, hold on one second. Someone's calling for me. I guess, one moment. May I have a moment to step out before we break on this one? Because I guess they're calling specifically about this.
are they calling the court phone?
No, me, Judge, because they can see what's going on with the live, so.
Okay, I guess let's just, you're a
That's
popular
amazing.
person today.
Yeah, I guess so.
One moment, please.
You know, usually it's not a,
I know, usually case gets dismissed, property gets returned. I don't, so it wasn't any sort of plea deal where we said we would forfeit the gun or anything like that, so.
okay, so, hey, yeah, come on
I've
up.
got something easy, Judge, unlike these guys.
Agreed motion, it wasn't an agreed order.
Hmm.
So they filed a motion, you
Oh,
automatically
I saw.
signed it, but I had also filed my motion to return the same day. So that was my way of objecting to their motion. You may not have seen my motion and that's okay, Judge, but I didn't know you were gonna summarily sign their unagreed motion.
So I
If
take,
he's enabled, because there's no harm, no foul by doing it. Because, well, Dave, and think about it, because if I unsign it, the weapon is protected in the event that they can prove it, right? But if they can't prove it, I can just go ahead and re-sign it anyways. Right. And then no harm, no foul. Right?
so I,
If it's set,
is, I'm sorry?
if it's set aside, they're gonna have to refile it again. It's like.
Well, yeah, but I mean, I can always re-sign it, a new one.
So I disagree with at least 3 things, but I'll go in order. The first is that we still contend that the notice requirements were met and council hasn't presented anything, at least on the record or otherwise, after the initial motion was filed by our office. And if he was still attached, the notice being sent out for the person attached, because you said you were originally on the UCW, right? I haven't checked.
I am,
Yeah.
I'm still attached to the UCW.
Right.
The same day I got notice of their motion being filed, Judge, is the same day I filed my motion to return property, within minutes.
So at that point, well, and again, for the purposes of the order to set aside, as council hasn't presented anything on the record, and to, hold on, I'm trying to figure out which way to go in order, but
So how long from the time that you filed it, or I'm sorry, from the time that you got that notice was signed, or the return receipt requested was signed, did you present your motion for me to have it
let me
destroyed?
get a better time.
You know?
with the case right in front of me.
And then, I mean, to me, ultimately, there's no harm, no foul for me setting it aside until we make a decision on the motion to return, you know?
So,
You're not at a loss.
well, just
Day.
regarding the refiling it, which, again, I don't take the order of putting in and just setting it aside casually, especially when council hasn't presented anything on the record.
Let's get a court reporter out. He keeps saying on the record, let's get a court reporter out, Judge.
But
Let's do it.
no, we're talking now. I mean,
If he wants to be so
Make a difference
unreasonable,
with-
let's get a court reporter out.
no, I mean, it's. What else do you have, Dave?
Well, I probably
Anything
want
else?
to at that point talk to Brian, because this is largely, so I'm subbing in, because typically this is something that's handled by the trial bureau, but this is one that was, I guess, brought to, I don't know, do you know who originally brought it to Brian's attention? Okay, so I don't know who originally brought it to, obviously my boss's boss, and so this isn't typically what we approach for. So if Pavel wants to talk to Caroline, or if I can talk to Brian, this isn't normally what I normally do. So I can reach out and ask. I don't have any problem doing that.
A little bit of time? I mean, I know what I'm gonna do regardless.
Okay.
Because I just don't think that you're not harmed by it in any way. Because if they can't prove it's their gun, I can always re-sign your motion anyways.
To destroy it, right?
Right.
And then,
But if they can prove it, and, you know, I don't want someone to accidentally destroy it. Oh, I didn't see it. I didn't get it. You know, it went to my junk mail.
Well, that was the whole point of me saying, well, I was in the middle of the sentence of saying the email from me today that I'm going to inform everybody in CCU at the court. So that's how I would make my assurances.
Okay. I'm gonna sign this set aside now. And then just get your argument ready as to if you think if it's someone else's gun, I'm not gonna give it back to them. That's it. I only want to give it back to the rightful person. That's it.
okay,
If that person exists at all. We'll see. Okay, all right.
great, thanks, Judge.
For sure.
Okay, that was cool. I don't remember that at all happening, and that was very cool. Maybe I was sleeping that day. I did take a day off. Maybe that was Monday because I was at the vet. Maybe this was Monday instead of Tuesday. I don't know. My days get smushed all together. But I have to find a cat that's definitely hidden right now, who does not want to come out for me. Because last time she came out for me, I threw her in a car carrier and drove her across town for no reason. And I have to get there in 28 minutes. That's fine. We'll be okay. Thank you so much for this longest 3-hour stream. Thank you, Judge Simpson, for dragging that on so long, making my stream long. Oh boy. I really appreciate you guys coming out. I love this chat. This chat, like, it really does start the day off great or end the day, depending on who you are and where you are. I wanted to get a Kelly trial out yesterday, but I got sucked into Tokyo's stream and loved it. So I stayed there and I wasn't able to get a Kelly trial out. I will today because I have off today. Plenty of time to do a Kelly trial. So you'll see that soon. And on my Patreon, I have the full, it should be released now. So I have the full trial of those two knuckleheads. If you wanted to see the full trial, it's there on my Patreon. Thank you so much for coming out. I hope you guys have a great day in Judge Fleischer's courtroom, and I will talk to you later. Bye, guys.
Got these lights that goes digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Tales waiting to the night. Her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Her eyes hear sky so blue. In her jokes there's a truth so true. With each stream she brings the light, turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's laugh cuts through the gloom, eyes blue like a summer's bloom. Her humor like a twisted charm. In a way, there's no alarm.